happens, for an example, where there are minority views in a committee meeting? And this rule really tries to address that aspect. And it provides that if in a report, there's no unanimity, this report should specify in which respect there was no consensus, and in addition to the views representative of the majority in the committee express any views of the minority in the committee and record the result of any vote. So this is probably one of those rules, Chair, that members might want to reflect as well. Also, the next rule really is just minor changes. I don't want to waste members' time on that, but rather go to part 2A, which deals with the rules applicable to virtual and hybrid joint meetings. Honorable members, I think just as a background to say that subsequent, of course, of the advent of COVID, which has kind of
One again.
I think the colleagues must help.
Yeah.
Can you hear me?
Who's the colleague who was going to help you, because you're breaking up continuously now? Where the other colleagues of Mr. Nonyani, unless he was working alone on this?
It will be very surprising because I see lots of staff members in the meeting.
Can somebody else assist, please?
Can you hear me, Chair?
Yeah, we hear you for a while and then you break.
I break, okay.
I can hear you now.
You can hear me now?
Yes.
Yes, I didn't want to waste time. This rule really is, it mirrors the rule as they appear in both the two houses. The only thing, we didn't have these rules when it comes to the joint rules. So it really provides for everything that has to do with virtual and hybrid sittings, in particular, the question of the venue, because of depending that the seat of parliament will be the venue, the distribution of papers as well, that electronic papers will suffice, the question around the privileges that members enjoy in your normal sitting, that will also carry over in respect of virtual or hybrid sitting, and the question of presiding of members. But more in particular, we have also looked at what has been the current practice that seems to be working when it comes to voting, that when it comes to voting, both raising of your hand, but also take into account that technology, like as it does now, might fail us, that those members who are unable to, they may as well vote through voice by indicating whether they support or not, and also including the participation of the public. So in essence, this rule really, I thought members are more familiar with in terms of its operation. So in as far as the need, I suspect that members won't find it difficult really to see the need, except of course, if there are any areas that members might want us to further improve on. But just to say that it mirrors really exactly what the rules in the NA and in the NCOP provide when it comes to virtual and hybrid meetings. The next part, Chair, through you, has to do with the rules applicable to joint subcommittees. In particular, Rule 9.1, Sub-Rule 1B. There really also, it was just a textual, but more in particular to make a reference to the fact that initially it was talking about the task. So we thought the task was more limited, but to expand that rule to talk of functions assigned, and so that at least it's more broader. So that really is the proposed changes. And on the very same rule, Rule 1, Sub-Rule D, you'll see there we are also proposing that instead of a procedure, because procedure as well is more limited about the way in which the committee's procedure works, but rather to talk of working arrangements, wherein it will be more broader to encompass issues beyond just the procedure. The next rule where the substantive changes, Rule 94, Sub-Rule 1, dealing with chairpersons. The rule reads, a parent committee of a joint subcommittee must designate a member or members of the subcommittee as the chairperson or co-chairpersons of the subcommittee, as the case might be. So this mainly will be something similar to what we currently have in this subcommittee on review of joint rules, is a committee which is parent committee.
Yes, Mr. Nanyani, don't run away.
Of chairpersons and co-chairpersons. The next rule where the substantive changes will be the rule relating to the Joint Rules Committee. That also, Chair, the issue there in particular Rule 112, Sub-Rule 1, is about deleting some of the committees that have been there, and this really is subsequent changes take into account that some of the structures within Parliament have since changed. For an example, we now have the financial management of Parliament that spells out as to how then, the reporting in respect of the finances of Parliament and the like. So the old subcommittee that deals with the budget has now been phased out. But also we now have, for example, the PGIR, which is a new structure that deals with international relations. That also, for example, those subcommittees that dealt with the PGIR. I said previously it was on international relations. Those subcommittees, due to the time and the manner in which, for example, new structures have since been established and operating, then we were just cleaning the rule in order really to respond to the new developments. Chair, I'll now move to Rule 117, which at least amplified the point that I was making around the number of joint subcommittees that we are proposing that they be deleted. As members can see that they are in bold. This includes the joint subcommittee on support for members, as I said earlier on. We now have the financial management of Parliament, joint subcommittee on international relations. We now have the PGIR. However, I would want to bring members to rule, in particular rule dealing with subcommittee on delegated legislation. It is one of the rules that is highlighted as being proposed for deletion, but I thought I need to bring this into context so that at least when members pronounce on this as well, they've got a background to this issue. The Joint Subcommittee on Delegated Legislation was informed or is informed by the provision of the Constitution, and specifically Section 101, which talks about Parliament in its own rules should provide a mechanism to deal with subordinate legislation. Subsequent to that, in both the second, third, and fourth Parliament, there were a number of studies that were commissioned to look into how best could Parliament deal with delegated legislation. Reports were compiled, and as such, there hasn't been really a clear direction as to whether subsequent to those reports, is there going to be a specific mechanism that will deal with delegated legislation, or delegated legislation will then be treated or dealt with by the respective committees, depending on which committee specifically those delegated legislation relates to. So due to the fact that this really committee has not been functioning for some time, this was one of the rationale that informed, for example, the proposal to this committee that might be it's high time that this subcommittee be deleted. But also on the other hand, as I indicated, we still have some of the legacy issues relating to delegated legislation as to whether which structure then will be driving that aspect if we were then to deal with or do away with this subcommittee on delegated legislation. So we thought just to bring that to members so that at least the members then can pronounce themselves with that in mind. But more specifically in the NCOP, the Section 146 of the Constitution gives the NCOP a unique role in as far as where there is a dispute between national legislation and provincial legislation. So as to a mechanism to deal with that, should this committee then also go ahead to thresh out all of those things that are contained in the reports and then make the necessary recommendation as to how then, including the NCOP, it should deal with those matters. So these are in broader perspective, the issues that this committee needs to take into account when they pronounce on whether we should have this or we should do away indeed with this as proposed. The next part is the Joint Subcommittee on Powers and Privileges, which I think is the next committee that will be doing it away, which is Rule 121. The substantive changes are in respect of Rule 123, starting from A, dealing with the functions and powers of the Joint Subcommittee on Powers and Privileges. Just to read the proposed changes, the subcommittee must deal with any matter affecting the powers and privileges of members arising from joint business referred to it by the Speaker and the chairperson acting jointly, and B, must deal with any matter affecting the powers and privileges of members arising from joint business referred to it by a member or members, and C, may deal with any matter relating to the powers and privileges of members arising from joint business on its own accord. Members will recall that made to understand that particularly in the National Assembly, there is a specific committee, for example, including when members have been taken out of the House. So in the joint, the powers and privileges will be one of those committees that will then be seized, including dealing with those matters as well. The next substantive changes really on the next is Joint Programming Committee, which is mainly around the deletion than any other thing. The reason being that we have since weighted the rule, particularly when it deals with the composition, that is 125 sub-rule 1, that both the component of the NA program committee and the component of the NCOP program committee will form the joint committee. And therefore, we felt that it is not necessary to have the composition spelled out in the joint rules, because of both rules of the two houses will then determine as to how each house is structured, and that the two structures then they will form part of the joint programming committee. So that is really what informed those deletion and the insertion as they appear on the rule. The next substantive changes, Chair, will be in respect of the rule on the Constitutional Review Committee, in particular, Rule 136, Sub-Rule 3, is just the addition that the Constitutional Review Committee must consider and make submission on any bill amending the Constitution referred to it by the Speaker or the Chairperson. Usually the mandate of this committee really was to review the Constitution annually, and as such also go through all those processes. But we are now proposing, for an example, that there be this insertion that the Constitutional Review Committee may as well look into any bill that is amending the Constitution that has been referred to it by the Speaker or the Chairperson. Chair, the next rule has to do with the mediation committee. With your permission, Chair, allow me to request my colleague, Advocate van der Merwe, to take members to that part of the joint rules. Thank you very much, Chairperson.
Thank you, Mr. Nonyane. You finally were able to finish with all of the breakups and so on. Did break our momentum of following you. Is there anybody else who would add before I invite members?
Chair, if I may just add, I can brief the committee on the mediation committee. May I perhaps proceed now, or would you prefer to have members comment on what has been presented up to now?
If that is part of chapter 3 and 4, please offload that. Please go ahead.
Thank you very much. I'm going to switch my video off just in case of any problems, so that I hopefully don't go quiet, but I thought just to show my face so that members can see who's talking. So on the mediation committee, the concern was that we didn't have a clear starting point. We also have the challenge of the rules speaking about the mediation committee already being established, but that is not the case in practice. There are a lot of practical challenges if we regard a mediation committee as a single committee that exists within Parliament. Your legislation that they must consider may be very complex, especially if there's a dispute between the two houses. The issues involved may be complex, and you actually need the members who have been a part of the process to consider and discuss. So the proposals that we make in respect of the mediation committee is to indicate that there will be a mediation committee established per bill. In other words, when it is required, there will be this establishment. And then, of course, it must be done as soon as reasonably possible. And then once it's established, then we have that bill referred to the mediation committee, and the timelines in the Constitution will then start to run. So it is really just to make it very clear what the actual process is, so that we don't have a situation where, it is unclear and we don't know where is this committee, why, when is it happening, and so on. If we can go down, please. So the new rule 139 simply just builds on that. 140 the same. It doesn't really change. It's more consequential amendments based on the fact that there's a new rule. In respect of the new rule 142, it is just to indicate that your referral is for mediation, and it will be able, per committee, they will be able referred. The next rule 143 is simply a consequential amendment based on definition changes. And then in 144, the new 144, what we just want to clarify here is that Section 74 does not really provide, in fact, not really, does not provide for a mediation process. However, both the houses are involved, both the houses' decisions are very important. It's a constitutional amendment that we're talking about. And therefore, it is understandable that there should be a mediation process. But now, when we look at decisions in a committee, this is clearly not what Section 74 requires, but it is a committee that is making a decision. So what we're trying to do with Sub-Rule 3 is just to say that, yes, in the mediation committee, this will be the decision process, even on a Section 74 bill. But of course, when we get to the House, then in fact, it will be the voting majorities required by Section 74 that will be applied. And I can confirm that this is also the practice in committees at the moment. In the committee itself, it's a simple majority that carries the vote. Once it goes to the House, it is the majorities required by Section 74. So if I can then go ahead on Part 9. Part 9 is being combined. Our proposal is for it to be combined with Part 14 ad hoc committees. So I will speak to it under Part 14. So at this point in time, our proposal here is for this part to be deleted. And the rationale is simply that this committee, which is a joint committee that will be considering legislation, which is required by Section 45 of the Constitution, is in effect an ad hoc committee. It is something established for a specific task, etc. So to join it with Part 14, which deals with ad hoc committees, allows a bit more flexibility. So we are proposing that it is combined there. So if we can go down, please. The next part deals with the Joint Standing Committee on Financial Management of Parliament. Chair, with your permission, if I may, at this point in time, just hand back to Advocate Nonyani. This is not something that I worked on. It doesn't look like a lot of amendments, but just in case I'm not aware of any that must be raised.
Have you covered all areas that you're supposed to cover yourself?
No, Chair, there will still be some. Going down, but if we're going in consequence, with the numbering, then at this point in time, it might be better for Advocate Nonyani just to come in here and speak. Or what I can do is we can go down. I can look at what is there, because it doesn't look like a lot. Can we go a bit down?
So as we go down.
Let's go down. Yeah, Chair, I don't think there were many changes there anyway. So, where are we now? But the next one I definitely have to hand to Advocate Nonyani, the issue of ethics. Oh, what are we doing? Are we going down first for mine? Okay, that's fine. Let's go to Part 14. Then I can finish and we can go back. And Advocate Nonyani can finish up. So let's go stop there to ad hoc joint committees. So what we've done here is simply to then now join Part 19. So we're making specific provision for a committee that is contemplated in Section 45 of the Constitution. As I said, it's required that we have that our joint rules make provision for joint committees to consider Section 74 or Section 75 legislation. So all that we have done here is to actually just put in things that weren't in the ad hoc committee part, so that it is clear that it now provides for both legislative type of bodies and other ad hoc joint committees. So if you see 3A, we're just referring there that they must take cognizance of legislative processes. when it comes to sub-rule 5, this is more just to speak about the fact that an ad hoc committee needs to be able to continue under certain circumstances. So we set a time limit, but of course we can revive them because there may be a need for them to continue. Specifically, for instance, on legislation. The legislation might be finalized in the houses, but the president still has to assent. If the president sends it back, we may need to revive that committee then. So if we can go a bit down, please, to composition. I think this to me looks just like a kind of a technical amendment, talking about the members, just to indicate that there must be some consultation. And then also where, you know, the fact that when members are appointed, that there is some consultation in arriving at the composition of this committee. Sub-rule 2B there is then again bringing in part 9, because when it comes to joint committees sitting on legislation, the rules provide for local governments to have a representative in that committee, although they cannot vote. If we can go down a bit more, please. On chairpersons, there's not really any changes, the same on decision making. If I am to complete, I think there is still something on the joint tagging mechanism. So if you could go down. There, by part 18. Okay. So what we have done here is just a few changes. Some of them are as a result of changes in the law. Because of judgments, there's been a change in legislation as well. We are also proposing that when it comes to the joint committees on legislation, that we utilize the fact that this is a legislative process that's being decided on, that we utilize the joint tagging mechanism as a body to make that first decision on whether a bill should be considered in a joint process. It is something that has a bit of a discomfort to it. The Constitution requires us to have it, but we have been given so many hidings by the courts that I think we're all a bit cautious of that process. So the proposal is that there must be a technical body that considers whether a bill is suitable. It shouldn't just be something that happens out of the blue. A minister asks and Parliament just has to comply. The proposal is, let us have a technical body like the joint tagging mechanism. And we do provide that they make that decision after consultation with certain bodies. So if we can, the one that we are deleting there is on the mixed bills. So the issue there, and you will see that repeated throughout the rules where we're deleting all mention of mixed bills. And the rationale is simply that between the liquor bill case as well as the judgment on the Tongwane case, the courts have made it clear that if a bill is mixed, it is a 76 bill. You must proceed with it on a 76 basis. So at this point in time, and it's not really a process that we've been using. In fact, when executive has been introducing, they would rather do a first and a second amendment bill and split the bills themselves. But so because there is no need where even one clause it falls in section 76, the courts have said that whole bill becomes a 76 and must follow that process. So all those referrals to mixed bills here on 75, 76, as well as in respect of constitutional amendment bills. Because remember, there's one type of constitutional amendment bill that doesn't have to go to the council and the rest all have to go to the council. So even if one part doesn't have to and the others does, it becomes one bill that has to go to the council according to the courts. So that is what we are proposing there. And then I think there's one more issue here. Can we go a bit down? And like I say, these amendments just permeate throughout. On sub-rule 4, we are proposing the removal of that phrase, but are not bound by any legal advice. And the reason for that is simply interpretation. In sub-rule 1, we also speak about advice, but we don't say there that the JTM is not bound by that legal advice. Now, the problem is, you see, there we say in 1, and a legal opinion on its classification, but we don't say they're not bound by that. And the problem with that is on strict interpretation. If something is included in one part of a section and not in the other, then it is not relevant in the other. So you almost have then you could have the interpretation that this first legal opinion does bound the JTM, which of course is not the case. So it is not necessary to state that they are not bound by legal advice. Advice by its very nature is not something that is peremptory, and we just propose that it is deleted there. It is superfluous, it's administrative in nature, and it just causes interpretation challenges. If we could still go down a little bit more, please. So the next change is there in 205. That also speaks to the joint process. The same in respect of 206 to speak to the joint process. Just to say that there will be a finding from the joint tackling mechanism, which will then be considered by both houses. It's not binding, but must just be carefully considered. So just extra caution. We're building in a lot of caution in respect of any joint consideration. There needs to be a number of decisions before that happens. If we can go down a bit more, please. Are we done? Is that it? Okay. The other changes that to the joint tackling mechanism will then be in chapter 4. So if I can hand back to my colleague Africa Nonyani, I think we're starting from the financial management of Parliament committee that he still needs to brief this committee on, but my part on chapter 3 is done now.
Okay, Mr. Nonyani.
Thanks, Chairperson. In fact, just quickly, in respect of it should be Rule 152 on the Joint Standing Committee on Financial Management of Parliament. There aren't any changes in there, except what I want to bring to the attention of the committee is in respect of the Committee on Security Services. There are changes, the oversight of security, that the proposal that that rule be deleted. And the next part should be on the rule relating to the rule on defense, Chair. We have received a request from the secretaries of the two houses that through you, this matter be deferred to a later time, taking into account that there are several issues that they still need to consult. And only then when the consultation process is done, that they will be able then to present to the subcommittee. On that note, Chair, I think what then will be supposed to be considered will be the rules on the intelligence, which I think we've got also a colleague from the who support the Joint Standing Committee on Intelligence, that is Mr. Nati Tsechana. So we requested him as well to take the committee through that. And thereafter, then it should be the Joint Standing Committee on Members' Ethics. Thanks, Chairperson.
Can Nati come in?
Good afternoon, Honorable Chairperson and colleagues, members and colleagues. Chair, I'm Natim Tengano, advisor of the JSCI on this matter today. And there are only a few proposals for consideration for amendment by the JSCI, and those relate to, number one, the special report in the regulations, which would be M, clause M, which reads as special oversight report, means a report prepared by the Inspector General of Intelligence on the request of the committee, being the JSCI, when the committee deems it necessary for the purpose of executing its constitutional mandate of oversight over the services, being the intelligence services as contemplated in the Act, and the Act would be the Intelligence Services Oversight Act. So that's the proposed inclusion into the definitions of the Schedule B, Honorable Chair. Schedule B is the one that is regulating the work of the Joint Standing Committee on Intelligence. If I could just ask colleagues to scroll down, Chair, so that we can move on to the next amendment. The next amendment is on clause 4, Chair. Clause 4, subsection 4. The new clause that is proposed reads as follows: the chairperson may request for certain matters, which were decided in his or her absence, to be revisited within reasonable time of such decisions, if the chairperson is of the view that it is reasonable and necessary. The intention, Chair, behind this amendment, proposed amendment, is that where the chairperson of the Joint Standing Committee on Intelligence is not available, that an acting chairperson be appointed to preside over meetings of the JSCI. However, Chair, because the Act does not provide for the acting chairperson, that when on the return of the chairperson in terms of the Act, the acting chairperson then brief that chairperson, the appointed chairperson in terms of the Act, appraise the chairperson of the decisions taken in his or her absence. So that clause, Chair, is intended to just do that, so that it's not a matter of the acting chairperson having to grant the power. The previous clause that's being amended, Chair, provided the power of ratification to the chairperson, which was almost the power to start the processes from scratch when the chairperson comes back. So now the attempt, as per the committee's request, is that this clause must be a bit toned down, so that the acting chairperson only must appraise the chairperson on his return, without necessarily the chairperson having the power to ratify almost, which was used in the manner of almost starting processes from scratch when they have were well progressed. So that's the proposition, Chair, and that's the background towards to that proposition. And the last one, Chair, which is proposed by the committee, is related to the lawmaking powers of the joint committees. So this proposition, Chair, which is now cited as 6.1, was actually not meant to be part of the schedule. However, it was a general proposition or request of the Joint Standing Committee on Intelligence to be considered by the Rules Committee, that the joint committees be granted the procedure in terms of the joint rules to process legislation that is referred to the joint committees in terms of the rules. In respect of this, it must be noted that Section 45, subsection 1B of the Constitution provides that joint committees have the authority to process legislation that is referred to them. The limitation, Chairperson, for joint committees is that they cannot in themselves introduce legislation in the two houses. However, it is anticipated, or at least envisaged by the Constitution, that joint committees may process legislation that is referred to them. Now, the Joint Standing Committee on Intelligence, being a specialized committee that oversees intelligence services, considers itself to be the best committee to be able to legislate in the area of the services, because it would have the benefit of oversight over the services over a period of time. However, in terms of the rules as they currently pertain, it cannot process legislation. This is the background to the request of the JSCI that the rules be amended, the joint rules be amended to provide for a procedure for processing of legislation that is referred to the joint committees. So it's not meant to be any of the sections in the Schedule B, Chair. So where it is reflecting a Section 6A, that would need to be moved, Chair, because that was a general request, not directly linked to the schedule itself. Thank you, Chairperson. That is all from our side.
Thank you. Ethics.
Thank you, Chairperson. Sorry, I'm so used to joint committees. I'm Anthea Gordon, Advocate Gordon. I'm with the Ethics Committee, and I'll be speaking to the parts of the joint rules that relate to the Joint Committee on Ethics and Members' Interests. Chair, the presentation today on these amendments, or rather the proposed amendments, are not substantial changes. They are more administrative matters. Looking at the composition of the committee, in Joint Rule 165. The old rule made provision for 14 members of the National Assembly to be allocated to the joint rules of committee. Having looked at the background on where the number 14 came from, it appeared that the number 14 was a legacy number from previous parliaments when the portfolio committees of the National Assembly were comprised of 14 members. So with the incoming of the 6th Parliament particularly, we still had 14 members of the National Assembly who comprised a part of the Ethics Committee. Now, of course, we know going forward into the 7th Parliament, there are going to be all sorts of nuances that may affect how the portfolio committees are indeed constituted. And it would be incorrect for the Ethics Committee to be comprised of 14 members, give and take, but we are uncertain of how the National Assembly portfolio committees will be structured going forward. On that basis, the recommendation is to align the structure of the Ethics Committee to how joint committees are usually structured, and that would be in respect of the NA component, the proportional representation. So the wording in 165(1)(a) would now be that the joint committee consists of members of the Assembly, taking into account the substantially the same proportion as how they are represented in the Assembly. What remains the same in this rule will be the 9 members allocated to the Ethics Committee from the Council, because that would take into account the structure of the 9 provinces, so that we remain proposing to remain unchanged. The next amendment would be in 165(2), where normally the chairperson of the council would appoint the council members to the committee. The rule currently states that it would be based on the parties of provinces, but we all know that the allocation would be done by the chief whip of the council. So that's really taking into account the actual way that the representation in the committee is done. Joint Rule 166, that's just a clean-up as well, that the Joint Committee on Ethics and Interest must appoint the chairpersons and not necessarily elected, of course, after the elections when the committee is constituted. The election procedure takes place, but the appointment of the co-chairpersons will be done in terms of the rules provided for in the joint rules. If I can just scroll down further, if I can look at 167, Joint Rule 167. What we've done over the proposal in 167 is not anything substantial. It's basically a change in how 167 reads. 1671C used to be the old D. So I'm just switching up D and C, moving it around, that the reading of this rule flows better. The joint rule provides that the Joint Committee on Ethics needs to implement the code. We need to develop standards, and then we need to regularly review. So when one reads it, you now get a crisp understanding of what it is that the Joint Committee on Ethics is required to do in respect of the code. And then the new D would be that we act as an advisory body and we perform the functions provided in terms of the code. So nothing has changed, only C and D has moved one up, one down. Next joint rule, please. I think from there we would go down to the membership confidentiality. Yes, joint rule 170, sub 1. Each member and each alternate member. Currently, the joint rules make provisions that the Joint Committee on Ethics has alternate membership. It's a provision that's never been applied due to the nature of the Ethics Committee. We work on a confidential basis. We can't have alternate membership. It would mean that members are sworn in, and then we would have alternate members coming in to discuss matters that are confidential, and it would not allow the flow of work before the Ethics Committee to proceed how it's intended. So the recommended proposal is that we delete the words "an alternate member" and therefore only make provision for the number of membership that we would have in terms of joint rule, the new joint rule 165. Thank you, Chairperson. I think that's essentially the recommended changes that we are proposing to the rules in respect of the Ethics Committee. Thank you.
Thank you, Advocate Gordon. Back to you, Ms. van der Merwe and Mr. Nonyane, to conclude on the other section.
Chair, I think taking from where my colleague left, the next part was just the parliamentary group on international relations. There aren't any changes there. The only thing that I would like to bring to the attention of members, which we are proposing that might be the structures, as said, is proposed already and is currently really not operating, that is the Joint Committee on HIV and AIDS, which is part 13, starting from Rule 137. We are proposing that structure really and the rule be deleted, since those matters are now seized by the committees dealing with health. The next is the multi-party women's caucus. I think there were no any proposed changes on that structure. Next will just be also some minor changes in respect of general ad hoc joint committees, which I thought just to highlight that to members, in particular, Rule 186, subcapital 2A. This really has to do with a resolution or a decision establishing an ad hoc committee for consideration of a bill that may include also indicating, for example, the timeframes for the reporting on progress on the bill. I think this will assist just to enable whatever house that the bill is supposed to come to after this ad hoc committee, that at least they are able as well to plan based on the proceedings of the committee and their report. And the next part really where there were some input in that respect is Rule 3 capital A, also has to do with the same ad hoc committee concerning of a bill. Here is just references to the rule and the chapter in the joint rules. I don't think I need to say much on that. The next part will be on Rule 5A, sub-rule 5A. If you can just go a little bit up so that members can see where it's underlined. It mainly start by providing for the resolution for the establishment of that ad hoc committee, and where, for example, the House is in recess, to enable both presiding officers to be able then to establish an ad hoc committee. As members know that sometimes ad hoc committees are necessitated by agency, and where there's recess, then the presiding officer should be able then, without necessarily waiting for the houses to start its business. The next part really has to do with Rule 187, that is the composition, in particular sub-rule 2, starting from A. If the resolution specifying only the number of committee members from each house, the Speaker must appoint the assembly member who are to serve on the committee after consulting the chief whip of the majority party when a member of the majority party is appointed, and the most senior whip of another party when a member of that party is to be appointed. And B, which talks to the NCOP, as I said earlier on, it was just to make reference that in the NCOP it will be consulting with the chief whip of the council. The next changes are in respect of capital 2A, that's in session as well. If the committee was appointed by the Speaker and the chairperson of the council acting in terms of the rules that I've just highlighted, the Speaker must appoint members who are to serve on the committee. Again, this is, I think, a repetition of what I highlighted in respect of who appoints in those instances of a constituency, where there's a constituency and so forth. That then, I think, should take us to the next rule, where also there aren't much changes, is Rule 191, Sub 2A, which deals with the composition of the joint committee appointed by Assembly or by Council resolution. The wording is nearly similar to what I highlighted earlier on. It's just to amplify that what happens where the resolution or the appointment is by a resolution of the House. Same as well when it's in respect of the NA, the consultation process, and in respect of the NCOP, the consultation process with the Chief Whip of the Council. Chairperson, I think this then should bring us to the end of chapter 3. I think my colleague as well should have gone through chapter 4, if I were just to confirm on that, because of then we'll be left with chapter 5, which is not that long, Chairperson, unless I get confirmation on that.
You're done with chapters 3 and 4?
Yes, we should be done with that. And the only chapter left is 5, which I think...
it's a separate item on the agenda.
Yes.
Apologies. Chapter 4 still needs to be presented. We are only done with chapter 4.
Sorry.
Please present.
Thank you. Chair, if I may ask if the sharing might just be taken off. Thank you. Then I will share my screen. Okay, there we go. So, Chair, the first matter that we are presenting is where we really need an instruction from the committee. On Joint Rule 159, as we also presented in the workshop, there were 2 proposals. The one was that this is becoming, the 159 deals with the notification that legislation is on its way. And sorry, I was just for a moment lost my, I hope that you can see my little demarcation block disappeared. If the sharing stops, please just alert me. So on Rule 159, there was a concern that because departments don't always submit this notice in time, it stops them from introducing legislation, so it causes delays. Sometimes it comes very last minute, the bill is not the same. So the one proposal was to actually delete this requirement. The other proposal was to say, but there is value in getting this information because it does allow for planning, and let us rather make it more strict. So the one proposal is to delete most of 159, but to place more requirements on the leader of government business regarding reporting to the programming committee and communication with other committees. The second proposal is to make it more strict and make it also apply to private members' bills. And to change it so that it is not after cabinet approval, but after certification, because certification sometimes delays bills quite for a lengthy time. So these would then be all these additions, also to indicate when they're targeting introduction. So making it just more strict, requiring more information so that we are more clear on what is happening with that specific bill. So 1A is just to also make it applicable to private members. And then just to put in a caution that if it is not submitted, it does not stop the introduction of the legislation, but it may affect the scheduling because, of course, now the committee did not have time to program. So then the same would be that the speaker would just indicate the estimated date. Then place the same requirement on leader of government business as proposed with the deletion, so that there's more communication with the joint programming committee, quarterly reports, and liaising with the actual committees. The next is then part 2, classification of bills. I've already spoken to some of this, so I won't repeat. One of the things that we do propose is that there is more said about constitutional amendment bills. This is not the type of bill that often comes to Parliament, and it is perhaps something that could be easily overlooked. There needs to be more explanation, more strictness on what is required for constitutional amendments. So that is part of what we propose in respect of the rules relating to what the JTM must do. So here we have some, including all the pre-introduction consultation, and then also the matter of joint consideration of legislation. So that I've spoken to already. Mixed bills coming out. This is the joint consideration of legislation. So I'm not going to repeat. Some of these are mostly relating to mixed bills. This is one I haven't spoken about, and where I said that there is legislation that have affected the rules relating to joint tagging mechanism. So we used to work with the Traditional Leadership and Governance Framework Act. That has now been repealed by the Traditional Inquest on Leadership Act. And this little part here is because a recent judgment, the Mohali case, the court actually found this Traditional Inquest on Leadership Act unconstitutional. So it is on its way back to Parliament, and at least this will change. So this 2019, Act 3 of 2019 will change. There may also be a change in the name, but that we don't know yet. So what we're proposing is, we know this is going to be replaced. So let us just say it, or any such act that may amend or replace it, so that we know we are covered. When that happens, we don't have to amend the rules. So here, like I say, again, the mixed bills, the joint committees considering legislation. Here, this is the matter of constitutional amendment bills, to just give a bit more of information. The publication, the provincial legislatures, submission to the council, that the written comments have been received. And then we propose that because we're doing that for constitutional amendment bills, let us also do the same in respect of money bills. So it just repeats what the Constitution says. It makes it very clear what the ticks are that the JTM must tick before it certifies a bill as a certain classification according to legislative process. Then in respect of out of order, so this also speaks to mixed bills. So in other words, if something is a mixed bill, then that will not be something that is relevant. We also, in Chapter 3, dealt with the issue of the deadline for Advocate Nonyani would have presented that, in respect of the deadline for the introduction. So we can't refuse a member to introduce legislation, but we can determine our program. That is what the courts have found. So in the Oriani Ambrosini case, that is where the court have found this. So we just propose that this is deleted, because we can't say that a bill is out of order because it is introduced late. A member is entitled to introduce a bill. Okay, so on this rule 162, there was nothing to be changed. Reclassification, this deals with mixed bills. It is no longer necessary. So all of that has been changed. This sub-rule 3 deals with, again, the Traditional Inquest on Leadership Act. I'm not going to say it again. It's exactly the same situation there. No changes there. Then we get to the next part, consideration of bills by joint committees. So as I've explained, Section 45 of the Constitution requires us to have this. And what we are proposing is to just make it a bit more clear, put a bit more process in here, put in who will make these decisions, how will it happen, when would it be advisable, and so on. So we're proposing that we make it very clear that there is other parts that must be read with this. And then how will this referral happen? Either by resolutions, or if they are not sitting, it will be by the presiding officers. Then we make it very clear, because remember that Section 45, as I said, only 74 and 75 bills can be referred. So we make it very clear that it is necessary for the joint tagging mechanism to first make a finding on classification. Only then can we have this referral for a joint committee. Section 76 may not be referred. And here we provide that the joint tagging mechanism, when they make this determination, that they may consult. So it's not a must, but it allows for that interaction, because there will be some political reasoning behind this type of process for a bill. It is inevitable, and that is why we just indicate this may consult. Then here is what we propose, that when, you know, so we have this, we must provide for it. Let us maybe give some clarity. So the proposal is where the subject matter would benefit, so a bit of a catch-all phrase. Where it is a Section 75 bill, but there may be something of particular importance to the provinces or to local government. Remember that there's a specific representative of local government in these committees. So that is a kind of bill. It's a 75. It won't follow the 76 process, but let us perhaps have a joint meeting and hear those views in the committee. The bill is purely technical in nature. I'm thinking, for instance, of the measurements where, the scales where you buy your vegetables in the retail. That was a very technical bill. It really just talks about the numbers and so on. That is the kind of bill that could perhaps just be sped up. We save on costs and so on. And then the last one in the only bill that actually remains as being urgent, constitutional court order bills, where there has been a suspension. But keep in mind that it has to be 74 or 75, so likely 75. And of course, all these other safeguards are in there, the decision making, the consultation, and so on. So it is not just something that's up for grabs. And also it is not something that has to be made use of, but we are required to have it. We may as well have rules that set out a very clear process and give some guidance. The process in the committee, here we've just made it clear we no longer have a discretion on public comment. It must be made. It's no longer a may. There's no discretion. The courts and the Constitution requires, and the courts have made clear that it is absolutely a must. Then what we have done here in Sub-Rule 3 is we have looked at the process and just expanded a bit on the process. So the Assembly rules make very nice provision for a process in a committee on a Section 75 bill. And we borrowed from there, of course, adjusting a bit. So to say that there must be a motion of desirability, because remember, if the bill itself is not desirable, then we might as well not, have other processes on this bill. It's a waste of time, it's a waste of money. So we'll start with a motion of desirability, talking about when you can do further amendments, if you want to extend the subject of the bill. Where it's a member's bill, just provide for that, giving the member opportunity. If it's a bill amending the Constitution, give the Constitutional Review Committee sufficient opportunity. This was, Advocate Nonyane also spoke to this. This was something that actually came up from a report of the Constitutional Review Committee, where they recommended that this be made applicable to them. Then just that there may be a consultation with the joint tagging mechanism on the classification of the bill. This last bit here just deals again with that issue of the Traditional and Khoisan Leadership Act that has replaced the Traditional Leadership and Governance Framework Act. This part here provides on mixed bills, but of course we've made it very clear. If the amendment changes to a 76 bill, the bill will have to be further dealt with in terms of the rules of the respective houses, because it can't be by a joint committee. Then here is this is also borrowed from the Assembly rules and dealing with Section 75 bills, just to say that there could be specific separate formal stages discussing the subject of the bill, the motion of desirability, public comment, deliberations, formal consideration, and adoption. Just give some clarity on how things will work. On the report itself, it's only to make sure that what the report needs to be referred to are only formal amendments. It's not just any discussion in the committee that needs to be captured in the report, because your report will become very, very long. Explanation of the report, no changes there. Of course, if there are any amendments proposed in the House, it will be referred back, but no longer necessary in respect of a mixed bill. But if it changes to 76, then it must go back to the two houses. So the only thing that really differs, and what we could find as something that has to be made very clear, is that the two houses, according to the Constitution and according to the case law, can receive a briefing together, can do public participation together, can deliberate on the bill together, can adopt the bill and make a recommendation to the houses together. But when it comes to the actual voting in the houses, the Constitution requires things happen in a certain sequence. So both in respect of 74 and 75, the Assembly must first consider the second reading, transmits the bill, and then to the Council. So this is just to make that very clear so that we don't have an accident where perhaps the council reads the bill first and the House hasn't passed it, and then we have a constitutional challenge. So just to make that very clear here. Then when it happens that this committee cannot reach consensus, the idea is that there will then be a report, and then the bill will proceed the normal way. In other words, we'll first go through the Assembly, a portfolio committee will consider it, it will be passed by the Assembly, and then go to the Council, where a select committee will consider it, it will be passed by the Council. So if they cannot agree, and we just, this was already in the rules, but we just expanded a bit on it because it wasn't clear, or if it is unable to report on a bill, how will they not be able to report on a bill? Even if you're in your report, just say we disagree, you are still able to report. So we made it just clear that if the consensus is in respect of either clauses of the bill specifically on an amendment that is referred, or to adopt a report on the bill itself, then the committee reports to the Assembly. Because remember, this is a 74 or a 75 bill. So the next step in the process will be a legislative step to be taken in the Assembly. So we require that we propose that the report the rules require that the report clearly indicate what is the cause of the failure, what did they agree on in respect of the bill, what steps have been completed. And the reason for this is to say that the Assembly may then consider this report and refer the bill to a committee in accordance with the Assembly rules, and may indicate the stage from which the bill must proceed. So say, for instance, the public participation has been done, everyone was satisfied with it, we've now agreed where we need clauses to be changed, and we just have a problem on one of the clauses, the wording on one of the clauses. Then it is not necessary in the Assembly committee for that committee to restart the whole process. They can simply proceed from deliberations on the bill and consider those amendments. Then the next part deals with constitutional amendments bills. This first proposed deletion is just on mixed bills again, that is no longer required. Then we propose a new rule, pre-introduction consultations. So these are things that, like we said before, because it doesn't happen often, it is such an important bill. If the Constitution is amended, we need to be so careful about complying with these procedures. But we then propose that the joint rules just indicates how the two houses work together. Who submits what is the next process, and so on. So in other words, when a bill is not to be passed by the council, you need to notify the council that this bill is coming. And then we say, if that happens in the council, the chairperson notifies the speaker, I've received notice that there's a bill coming that will not be passed by the council. Then the speaker can be aware of that and be on the lookout for this bill that is coming, because there's also a requirement that the council must have a public debate on that bill. So then the two houses are aware of what is happening. And then the second rule, just to say, this is what you must submit. The Constitution requires you to submit this. So submit then, this is how you will do it. Proof to the speaker and the chairperson of those publications, submission to the legislatures, to the council for a public debate. Submit all your written comments to the speaker for tabling in the Assembly, and the council, where relevant, for the chairperson for tabling. Then these submissions would then, we now say it in the rule, but in practice, it is just taking the one hat off and putting the other hat on. The speaker and chairperson then submits to the joint tagging mechanism, because this is the other problem that we have. How can the joint tagging mechanism make a decision on whether a bill is constitutionally in order if it is not given, if the information is not given to the joint tagging mechanism on whether Section 74(5) has been complied with? So this is just the proposal there to make sure that the joint tagging mechanism gets the necessary information. And then just the tabling in the ATC. So just by way of an announcement, because remember, if we get, someone advertises the bill, they get 200 submissions. That can't go into the ATC. It is totally counterproductive. Also, with electronic distribution now, we don't need that in the ATC. There can be links. So we just make it very clear that it will be an announcement in the ATC that there have been written comments received. So there will just be a link that takes you to the right documents. And then, of course, the public debate can only, in the council, can only be scheduled once the tagging mechanism, joint tagging mechanism has made a finding, because the person introducing might say that this is a bill that doesn't have to be considered by the council. The joint tagging mechanism may make a different finding, and then the public debate requirement falls away. So that whole rule just deals with Section 74 and how it should be implemented between the two houses. This is just a consequential amendment. The definitions propose that chairperson be defined as for the council. Constitutional amendments affecting specific provinces. Now, Section 74(8) indicates that if a constitutional amendment specifically affects a province or provinces, that province or provinces must approve that part of the bill. And the way that sub-rules 2 and 3 read was quite confusing. We didn't understand why the word lapse is being used. Even here, where part of the bill revives, or remains. So we're proposing that we delete these two rules and simply go back to the wording of the Constitution. So in other words, if a province does not approve the whole bill because the whole bill affects them, or an affected part because an affected part affects them, then the Council of Provinces either must reject the whole bill, or they may only reject the affected part and consider the remainder of the bill. And that is simply the wording of the Constitution. I don't think it's confusing. It makes it quite clear, and I think it is easy to act on. Sub 4 was a bit of an anomaly, because if a bill, and this is now the bill going to the provinces, has already been passed by the Assembly, it will always be passed by the Assembly before it goes to the provinces. There's no other way. A constitutional amendment bill must first be passed by the Assembly before it can go to the council. So again, we just propose that we make that sentence to read a bit better, so that it is clear that all of these bills, if the province now rejected the whole bill or a part of the bill, it must go back to the Assembly for concurrence in terms of the Assembly rules. So we have no amendments to 175 or 177 or 176. In 177, we have just made consequential amendments in respect of the new rules relating to the mediation committee. We have taken out this being referred, this regarded as having been referred, because we now specifically in Chapter 3 provide that it is referred as soon as the committee is established. So there is no doubt about it anymore. We can then do away with this rule here. That is just a consequential amendment to the definitions. No amendments to that rule there, 180. So on Part 5, Section 75 bills, very few amendments here, just a consequential amendment in respect of the definitions there. 76, the same, just a consequential amendment in relation to the definitions there. In respect of the mediation committee, the same comments here. So just to align it now with what we have now changed in Chapter 3, so that it will be referred when the committee is established. And of course, then we just say the secretary must provide these documents, not the period there, because the period has now shifted. So it's mostly just consequential in relation to where we now determine the referral. And the same thing here then, to just delete that referral because we make provision for it somewhere else. 187 is just consequential. 188 consequential amendments. None in 189 or in 190. The whole of Part 7 we propose be deleted because it deals with mixed bills, which is no longer required. Sorry, it's quite a long part. Let me just scroll through it. There. The next part is bills referred back by the President, so Section 79(1). The first proposal that we have here is that if a referral by the President is not clear, it probably is something in practice that would happen, but we propose that we include it specifically in the rules because there is such uncertainty about Section 79. There are some interpretations that are very, very strict, and that could prohibit some actions to be done. And the Section 79 allows allows the two houses, allows Parliament to make provision in its rules for the process to be followed. So we propose that we just make it clear that if something is not clear in the president's referral, that we could ask for clarification. When I did the presentation on the themes, I did explain, for instance, on copyright, the body of the letter referred to one clause, whereas in the end, the actual referral referred to another clause. Now, we could figure it out in that specific referral, but that is the type of thing that could happen. This is just consequential because I'll speak to sub-rule 3 now. Then sub-rule 2A is just to make it a bit clearer that we are limited to the reservations by the president. But if a reservation specifically refers to clause 4, but if we accept that, we will also have to make changes to clauses 9 and 12. But this is now not in the referral. Then of course we need to make it. It's a consequential amendment. So it's almost stating the obvious, but like I said, there are a bit of a challenge on the interpretation of Section 79, and on a strict interpretation, we will have to then provide for these matters in the rules. So also to make sure if it's, as long as it doesn't affect the substance, we pick up a typo, that we just can correct that there. But of course, to very clearly include it in the report so that it is absolutely transparent what was done with that bill. So when the committee then report, the paragraph A is referred to in future tense, and this caused, especially with one committee, it caused a bit of a uncertainty as whether there has to be 2 reports. So we just propose that this be made clear that it is past tense. They must indicate the steps that they have taken already, not that they, what they will still be doing. And then if there is any changes on the substance or resulting from the steps to correct the procedural defect. If we advertise for comments, that was perhaps the concern from the president. We can't say that we can't make any amendments because we're not allowed to. What would be the purpose of the public participation then? We need to give due consideration. So we're just adding here that is from the steps to correct that procedural defect. And if it is something that can only be corrected by the council, then to indicate that in the report. We've had one like this. It was the performing animals protection, where the only concern was a quorum issue in the Council of Provinces. So that is the kind of thing that will then be reported here. So the rest of the amendments here are actually just consequential. So just the debate will then include this consequential amendments, because of course that will now be part of the report. Then on procedural defects, here we are proposing that the current rule be deleted and replaced with something else. And I will first explain before I speak to the wording. So when we look at Section 79, there are a number of bills that need to be referred to the council. Your normal 76 bills and constitutional amendment bills that had to be considered by the council, but also Section 75 bills where the process affects the council. And in our view, even if there is then a rejection of the president's views in the assembly, that still has to be referred to the council. We can't just stop the process in the assembly, because Section 79 requires both houses to participate. And if we look at the rules do provide for conferral at this point in time, but if we looked at the court cases giving this, when they regarded the role of each of the houses, they've made it very clear that the one cannot rely on the process in the other. So our proposal here is then to make that very clear. So which bills can go to the president if the assembly has considered and they either agree or don't agree. If it's a constitutional amendment that is only by the assembly passed, or Section 75 and the procedural reservation did not involve the council. Then 2, all other bills must go to the council, whether it's a rejection of the president's reservations or not. The same on substantive defects, that we remove the rule as it is currently, and we simply say the following bills can go to the president. The 2 bills the bill that didn't have to be passed by the council in 74 and a Section 75 bill. All other bills must go to the council. These are then just also consequential amendments. And then the same in the council process. So these will now be just repeating the amendments from above and consequential. So those are just referring to the new rules, talking about consequential amendments, making the report a past tense instead of future tense, recommend how to do something. Say, no, it's not how you can do it. Tell us what you have done already. And then also if there was procedural matters or you have made amendments in terms of the reservations, to then allow that bill to be reported. The rest are all just, again, consequential to what I've already discussed. The same on procedural defects. Here, just the same. When does it go back to the assembly? And then if there is a disagreement, we need to have a mediation committee. Remember, in this process, even though it's reservations from the president, we still have the two houses playing a full legislative role. NCLP must be able to differ from the NA, and how to resolve that difference. We need mediation. And so that is what we just brought in here. And then we just indicate that the relevant houses rules will apply. Here it is just, again, it's substantive, the same issue. The fact that there may be, if they amend, it must go back to the assembly. If the NCOP amends, it must go back to the assembly. If they don't agree, then there must be a mediation committee. The next part deals with time limits, and we are proposing the deletion of fast tracking. And I will get to that, but just in the heading, you can see that we are proposing deleting fast tracking. So the time limits, 21214 refers to exceptions, so we just made it very clear that it's subject to those exceptions. We are proposing some time limits, and these months here were just proposals, in fact, so we need some guidance from the committee as well. When I did present on the themes, I provided some statistics, and from the statistics, what we could see on 75 bills is that more or less this would be a reasonable number of months, and on 76 bills, more or less a reasonable time of processing by both houses. This is again something that is required by the Constitution in Section 45. So it's a bit of a difficult one, because it is difficult to set time limits for legislation. We've been so many times told by the courts that we can't rush the process, etc. But also Section 45 requires that we do this. So just having extensions, please excuse the numbering. We will still definitely get to the numbering and correct that. This is just also to provide that when we're now talking about an extension, so we've now said 24 months, now something has happened, we can't complete in 24 months, then there must be a request for extension that will go to the Joint Programming Committee or a specific subcommittee established for that purpose. But if neither of them are sitting, then the speaker or the chairperson may grant that extension. We don't want legislation to fall foul of the rules just because a committee is not sitting. So on fast tracking, and as I've already sort of indicated in the previous discussion, it's very difficult to speed up or set a limit for how soon something must happen on legislation, because we have so many constitutional requirements. And over the years, those constitutional requirements have been just expanded on by the courts and making it more and more difficult for Parliament to act in haste. There are other ways of dealing with legislation faster. Bills can be prioritized, committees can sit faster, we can look at conferring of two committees, etc. So we are proposing that we rather do away with the rule on fast tracking. It hasn't really been used, I think, in the past. In fact, when we discussed this as the support team, we couldn't really remember when last the bill was fast tracked. So the proposal is for this simply to be removed. It is too risky. General matters, designation of members to be in charge of bills in the other house. This is not something that is really used. And when I presented, I indicated that in the National Council of Provinces, this phrase, member in charge of a bill, doesn't even appear. So what would be the purpose of designating someone in the council as in charge of a bill? This is not used. Members of both houses are welcome to address another committee, a committee of another house. So there is really no need for this rule, and we propose that it be deleted. On distribution of copies, we propose that "and permanent member of the council," this permanent be deleted because all members of the council should be able to get copies. And then we propose to add an electronic copy. And so the reason for that is simply that as we are working now, we rarely have the distribution of hard copies. Hard copies are available but not distributed. And remember, this deals with distribution. So you can always ask for one, but generally distribution happens electronically. We are proposing that this paragraph be deleted. The documents accompanying a bill on introduction is a certificate and the publication in the Gazette. Those we're not even aware when that could ever have been distributed. So just to align with practice that this is removed, it is not something that is required. For members to be able to prepare on the legislation. Then on the ATC, we propose that these first two paragraphs be deleted. This is at least the following. So this could still be included, but the way that it's worded here seems to be a separate requirement. Now, what this is the notice that a bill is to be introduced and the publication or explanatory summary. This is the Government Gazette. This is what A and B refers to. The problem is that this only comes to the attention of Parliament when the bill is introduced. There is no requirement that this is submitted to Parliament as soon as it is done. So this never happens by itself. The Government Gazette number is published with the introduction of the bill in the ATC. So we propose that this is removed here. It will still happen here with the introduction of the bill. Then DA is consequential, the tabling of written comments received by the public and provincial legislatures on a constitutional amendment bill. So in other words, here's the announcement that we've received those written comments. That is just consequential. This is also a consequential amendment to say that we don't announce the referral of a bill because that only happens once the mediation committee has been established. But the need for the referral for mediation, and then once it has been established, the actual referral must be announced. Fast tracking we propose to be deleted. And then language requirements. This here is something that from the Bill's office we've received some concerns to say that this doesn't happen. And they need to massage things behind the scenes to make sure that bills, the second reading of bills, are actually not delayed. So we propose that this is removed. We still will have something to say that where it goes to the President for assent, there must be an official translation. So it will still happen, but we just give a bit more time for that translation to in fact happen. So the proposal there is to delete it there. Remember that this language requirements does not relate to public participation. We must differentiate here. The language requirement here deals with the legislative process. So in other words, when the bill can be read a second time. Public participation is dealt with in a separate policy, and it is absolutely a requirement that there needs to be translations. But those translations are dealt with in a different way. This is an official text, and there are very specific requirements for how that is done. So that is the proposal there. Assent, there is nothing there. Subsequent amendments. When I presented, I indicated that we have two challenges here. The one is we want legislation in all the languages, all the official languages. On the other hand, we also need legal certainty. So if a bill is introduced in language A and translated into language B, we cannot have an amendment that is in language C, because your nuances are different, your phrases are different, and you cannot read the one with the other without a translation. So for that reason, we need clarity. And that is the proposals that we then make here to say that the official language must be the same language as the official text. And any translation must be the same official language as the language of the official translation. But or as Subrule 1A. And this is where we make provision for other languages. We propose that we make it very clear that bills may be translated in other official languages to give effect to Section 6 of the Constitution. And once this has been done, once a bill has been translated by Parliament into languages C, D, E, F, then your official translation may be in any of those languages. So then that removes the need for sub-rule 2. Chair, that is chapter 4. So finally, we are done with the presentation on 3 and 4.
Okay, thank you, Ms. van der Merwe. Maybe before I invite any participation and discussion, just to indicate, thank you very much for all of you for your presentations. I just got a sense that in 159 you rushed that a bit, and it's quite critical. It creates the genesis of both the opportunities and problems, and so much flows from it. And I hope members would have followed that, because we need to pay particular attention to that. In most cases, the executive give hospital passes to the assembly on all of these issues. So they will keep the work with them. On the 11th hour, when they're in trouble, it comes to Parliament. And 159 assists us to be able to deal with that. So it's quite material, but you quickly ran through it. But I hope members would have connected with that. I was in a workshop, and all of you made a marathon presentation. I think today still there seems to be so much which is very important, and I hope that we will not just want to tick the box and rush through anything, but you might have to come back on that 159. But let me invite members who wants to raise issues on 3 and 4. You would have listened and taken notes on all of these issues. So may I invite you to come in and contribute. Unless you're very happy and satisfied, or you've connected with everything. Honorable Papo, followed by Labeskagni. Are you Labeskagni or Labashane?
Labeskagni, Honorable Nyanti.
Okay, in Australia they call them Labashane. Okay.
I know. English-speaking people tend to call it Labuschagne. I'm not that sensitive. That's okay.
Thank you. Koorenoff, Lothrid, in that order for now. Honorable Papo.
The first issue I want to raise is what is the rationale for some of the amendments relating to the Joint Standing Committee on Intelligence? Because there's currently a bill which is undergoing public hearings to amend that whole area of why now? Can't we wait for? Is it not going to be better that we have the bill passed and then we then amend? But also that area of work operates differently from other committees, because you have to be vetted to be in that committee first to check whether you are a national security first yourself. The problem or not. Not every member can, it's assumed that every member, but some of the vetting comes back and then members are not appointed. There are reasons why. It also operates differently because it runs its affairs in a confidential environment, particularly when they present operational matters which require members to be aware of, but obviously they wouldn't do it. So what is the rationale? Because the rationale will then inform as to whether some of these amendments are necessary to that area of work. And also the members, the chair of this committee itself, was the chair consulted to get his opinions on these matters of intelligence. The second one is that on Section 75, we must stick to 1/3 and not talk about a quorum. a quorum which is not explained. 1/3, it's actually, we should stick to that. Section 117, we should delete this thing of the joint subcommittee on delegated legislation. Committees must deal with delegated work where required and not through a joint subcommittee. And then the last one will be that let me just check my notes. The issue of joint, because sometimes is it not necessary? It may be necessary that the two houses deal with legislation jointly, particularly the ones which don't have the responsibility. I mean, doesn't have provincial affairs, doesn't include provincial affairs. Why can't we deal with that jointly? Because it will be a national legislation which doesn't require. So we must have a clause which we're doing it, but NCOP then has to wait for NA on matters which in reality are national matters. They don't require provincial inputs. So we need to have that in the rules. And then the last part will be the part on that whole 202, that is submission of views of a committee to the joint tagging mechanism, only providing for 3 days. I think is 3 days enough? Is it possible to increase it? And looking at also I think that area needs a bit of work. Although, I mean, other members probably can actually beef it up, but I think we need a bit of work there. But for me, the whole rationale, because we must not also have two extremes on intelligence matters, where people want to treat intelligence matters like we're dealing with portfolio departments on human settlement and so on. And then people who say there mustn't be accountability, but accountability of intelligence happens in a particular manner. And I think generally it has been accepted. And the fact that politicization of intelligence and defense is very dangerous for any country. Thanks.
Thank you, Honorable Papo. Honorable Labuschagne.
Thank you very much, Chairperson. I just want to go back to the mediation committee, but based on what the honorable member Papo raised now on the intelligence committee, it is so that the GILA bill is being processed at the moment, but I think maybe we should get clarity on that. I think what we address in the rules is whether the joint standing committee, of which the JCSI is one, are allowed to make to handle legislation, a bill. So at the moment, the Joint Standing Committee on Intelligence is that Joint Standing Committee formed a subcommittee as prescribed in the rules, or if you may call it an ad hoc committee, and that ad hoc committee is dealing with a bill. The Joint Standing Committee is not dealing with a bill. And at this stage, it looks to me as if it is compatible with what we are prescribing, but I think we need to get clarity on that, make sure that we all understand that. Then I want to go back to the mediation committee, and I want to start off by, and I know that I've raised issues in the previous meeting. I think what my concern is, let me start there. I think my concern is that we are creating rules in trying to be very efficient, which is our aim, for something that has never been dealt with in Parliament up till last year. And the reason, and in the process, I think we must just make very clear, very sure that we are not creating a bigger problem for ourselves in future. And the reason why I'm saying that is I had a good look at all these things again, and I do understand some of the motivations for changing these rules, but as it was before we came with these recommendations, the mediation committee is dealt with in the Constitution under section 76 or 78, where the Constitution discusses the processing of bills. So my logic and my understanding of that is it's been put in there because the mediation committee is not for any other mediation except if the two houses have a difference on a specific piece of legislation or a bill. Therefore, it's been put in there. And how it must be put together, the compilation of that is described in the same way that the Joint Standing Committee on Intelligence and the Joint Standing Committee on Defense has been described in the sections where it deals with the security of the country. Therefore, mediation committee is standing there in the middle because it's part of the process of speaking about bills. Then in the old rules, something that was one of the things that was started this whole conversation is whether it was the chicken or the egg that's been first, whether a mediation committee should have been established by the start of a term or a year, or only if there's a bill. Now, if I understand that the mediation committee has been put there, all other joint committees in Parliament is established at the beginning of a term because it's been described in the Constitution as the mediation committee as well. Because in the existing rules, in Chapter 4, Part 5, Rule 186.3 on page 88 says that if a bill, or if there is a difference, a bill must be referred to the mediation committee within 7 working days after the Assembly or the Council has rejected the bill. So that rule has been there all these years because when these rules was written, I can see that people have the same way of thinking about it that I have. So for the fact of the matter that up till last year, Parliament in South Africa has never dealt with any bill that needed mediation. We were caught off guard, and then we didn't know what to do. That is it, that it has to be referred to mediation committee within 7 days. The way we are now going around it is saying that we first have to establish a mediation committee. It should not be established by the beginning of a term and then refer the bill, and only after the mediation committee receives it, that part in the Constitution kicks off. Now, what other, it's a question of interpretation, and I'm not going to fight about that interpretation, but the concern is the following. With the given geopolitical context, and I'm not talking party politics, but in the end, it boils down to that. If politics are changing and keep on changing as it is changing at the moment, we might find more bills that we will need some mediation for than we've ever had before. Because civil society is becoming very active, and they are taking part in processes as they should be. And any kind of coalition in any province is going to influence how we vote on bills, especially in the NCOP. So I am just very concerned that we are creating something that in the end is going to have more of a problem, because if a mediation committee cannot be put together like at this stage, we are waiting for now a year that the gambling bill is lying there and no committee has been put together. So that bill is going to lapse in any case, because nobody is dealing with it. If it's going to take that much time, we have the risk of maybe solving problems on a bill and pass a bill that might be good and necessary, or it might hang in mid-air, because all of a sudden maybe you can get in 6 months' time or 9 months' time, maybe 2 bills or 3 bills that we don't agree on, and then you have to establish 3 different committees in a normal, very busy working schedule of Parliament. So that is my long swan song on that, and that would be my final song on that. Chair, thank you very much. And I just want to say, in the proposal of the Mediation Committee as standing on joint committees or on specifically, just keep in mind that in the NA, yes, members in committee vote or on a majority, but in the NCOP, with the 76 bills, we vote in the committee even on provincial level. So for a normal 76 bill, 5, because our committees are put together, they have to be a representative of each province. Doesn't matter what the party is, because the negotiating mandate and the final mandate has been given by the provinces. Members in the committees does not make those decisions. You vote on what is coming from your province. So we vote according to provinces in select committees on 76 bills. Thank you, Chair.
Thank you, Honorable Abestaghi. Honorable Kurenov.
Thank you, Chairperson and members on the platform. I think firstly, we need to express a word of thank you to the staff and the officials and the advisors for their presentation. It's really, in my view, listening to it, a cleaning up, a lot of technical amendments, and a lot of alignment of the current rules as we have it. So thank you for that. Firstly, on the question that was asked was on Rule 75.2, whether you have a third of the members to for a quorum or no decision. I would recommend that we do the third as a minimum for a quorum. Section 79.5, we need to make a decision whether we will include the minority views there. Personally, I don't have a problem with that. Then on all the others, it's in my view very informative, but to a large extent technical and needed. Then I want to go to the Joint Standing Committee on Intelligence. Now, this oversight special report, as well as a process on legislation, I put a question mark whether we need it now. And because we need to consult with the members of that committee, especially the political leaders in that committee, and to make sure whether there is indeed for a process to process legislation on the one side, and whether we have a need, an oversight special report by the IG of Intelligence. So I just want to make sure that we may want to flag that and not make an immediate decision on it, but just to consult. We can still do it in the sixth Parliament before the end, but we consult members of the Joint Standing Committee of Intelligence, the chairperson or the members of that committee. Then the next one on the Ethics and Members' Interest Committee. Historically, we always had a problem to have a quorum on that committee. Currently, it's 23 members. So you need, if my calculation is correct, you need 13 members to have a quorum, which is quite substantive. Because members serving on that Ethics Committee and Members' Interest Committee has other committees. They have other committees that they serve on. And historically, there was always a problem. So I will just want to know, with a current proposal of the total number of members what will be the quorum? If I can just have clarity on that. Will be bigger than the current quorum because we now include provinces as well, 9 provinces. I just need to clarity whether we may not have a challenge that we have currently on having a quorum. Then on Rule 159, that is the chapter 4 on the Rule 159, bills refer back to President, by the President. That was a mouthful. I would love to just have a second look at it, but it seems on the first glance of it to be an improvement. But I just want to have a second look at that and come back on this one. And then what I miss here, and I didn't see it unless I didn't pick it up, the joint rules do not talk about any mechanisms for committees to process bills together. If I missed it, my apology. And if it was not presented, I'm asking the question whether that should not be part of the joint rules to have a mechanism for committees to process bills together. Thank you.
Thank you, Mr. Korenhoff. There will be responses. Honorable Lothrit.
Thank you, Chairperson. Firstly, also in terms of mediation, I think Honourable Labuschagne has covered me in terms of the concern about not having a standing mediation committee that is there, that has been established at the start of a term, as there is a possibility that mediation might be required more often. We don't know, and there is a concern about it having to be established every time when a bill has to be referred for mediation. So that is a concern on my side as well. Then in terms of chapter 4, I think Advocate van der Merwe also requested some direction from this committee in terms of the submission of bills, where 2 proposals were made. I think that the more stricter of the 2 is better, that there is more of a pressure and a responsibility on the introduction of a bill or the introducer, that it is, and I think if I understood her correctly, that it would be proposal 2, that the leader of governing business is also then tasked to oversee this process of making sure that we don't sit, as you correctly stated when we started this discussion, that we don't sit at the end of a term with a whole raft of bills that now has to be processed. So I think I would go for the stricter option there. Then Dr. Korenhoff also raised a matter that I was also very concerned about, and that is the mechanism of 2 houses looking at, joint committees looking at bills. How would that work? Because I have really a concern, and I would like Advocate van der Merwe perhaps to allay that concern, because she did refer to the fact that the NA committees and the NA committee, NCP and NA committees could jointly look at bills, and that there's no hindrance to that. But I am concerned that it would be used or can be used for expediency's sake, and not to really take our time in the 2 separate houses to each process the bills, interrogate the bills. I know that she said that in the end the 2 houses vote separately on it, but I'm not so sure that if you process a bill in the same committee with both houses present, whether the 2 won't influence one another. And I would be a proponent of separating the 2 houses when dealing with bills. Thank you.
Thank you, Honorable Lothrit, for your contribution. Can I now ask the 4 presenters to have quick responses on these issues? Members might come back as follow-ups. Mr. Nonyane, Ms. van der Merwe, Advocate Gordon, and Mjengane.
Afternoon, Chairperson. I will briefly, I think, just respond to some of the questions that members raised, and the others, of course, they will be responded to by my colleagues, starting with the question by Honorable Papo in respect of the Committee on Delegated Legislation. We know that Honorable Papo, and it definitely will ensure that, because that, of course, was one of those proposals that we asked. We now got a clear direction that that should then be taken out as the respective committee.
Mr. Nonyane, you can't repeat this now. We have to hear every word you utter. Please start again after that response. We want to hear every word you utter now. You can't be breaking, because we're looking for clarities.
Indeed. Where should I start from the beginning or just continue where I left?
You don't know where you left.
On the second question, Chair, which I think is mainly around Rule 75, that dealt with the issue around whether, for example, the meeting of the committee where they don't necessarily have to take decision.
Sure.
We made a proposal whether really it should be a 1/3 or the committee can proceed. And I think that point as well has been raised by Honorable Koorenoft as well. In fact, we appreciate, because of that giving us a clear direction. Honorable Papo proposed that in fact we should consider a rule wherein at least 1/3 of the members are present before a committee can proceed. So that we note, and we will definitely ensure that at least the rule then is adjusted to respond to that. The other issues, I think my colleague will be able then to respond to, unless if at a later stage there isn't any response from the committee, we'll see how then do we give a response to members. Thank you very much, Chair.
Thank you. Ms. van der Merwe.
Thank you very much, Chair, and thank you to the members for the questions. So I'll start with Mr. Parkworth. I think the one that affects me is in respect of the houses dealing with legislative jointly. It is still there. It is definitely still there. It is just maybe a little bit less visible. I think Dr. Koorenoft asked the same question. So what we have done is that we're proposing that part 9 in chapter 3 be deleted, but that we then pull from part 9 and place it with part 14, which deals with ad hoc committees. And then in part 14, which deals with ad hoc committees, we add the issues related to legislative committees. The reason for this is that part 9 specifically required that the committee would be the portfolio committee and the select committee. But there may be a reason to have other members sitting in on this joint process. So ad hoc committees allow for that. And we could have changed in part 9, that is so, but we're proposing that it just makes sense to have it as one. It is a type of ad hoc committee, and we will provide for it there. As I've said, Section 45 of the Constitution requires this. We don't have a choice. We must provide for it in our rules. If I may, just on this topic, remain on this topic. So I'll just quickly go to the other members that asked on the same issue, and then I'll come back. So I think Dr. Koorenoft asked about it. He said he missed it, but it's now in part 14. So it is just, we've added a bit. Dr. Lottrin had a concern, how will this work? Will this be abused? So yes, of course, there's a risk. Anything can be abused if allowed, and especially where we want to push things through, and things are often urgent in Parliament. So our proposal for this is that we are very careful. Currently, the rules did not provide for a process for this establishment. And what we propose is that we very expressly provide for some process. So the process will start with the joint tagging mechanism, because that is where we look at what the legislative process will be. Will it be 74, 75, 76, 77, which of course is then 75. So the joint tagging mechanism will make that decision. How it will get to the joint tagging mechanism is maybe a little bit of a vagary at this point in time, but it could be something that comes from maybe leader of government business, a request. Maybe when the bill is introduced, there may be a request, be something to be considered there. Might be something when we advise the joint tagging mechanism that we identify a bill as falling into one of these categories. Then we say that the joint tagging mechanism may, we don't want to say a must, but may consult. So look at the political environment of this as well. Then the joint tagging mechanism may make a recommendation, make a finding. This is a bill that could be considered in that way. And then both houses have to resolve that a joint committee is going to be established. So it will be a decision from both houses that they feel comfortable that this is something that can be established, that can be done by both houses sitting together. We doubt that there will be many bills that will qualify for this kind of thing. But for instance, and I think I've made this example when I did in the workshop as well, we had the Correctional Services Amendment Bill. And the process in the select committee literally repeated the portfolio committee process. The submitters were the same. Submission content was the same. There were no amendments in the portfolio committee, no amendments in the select committee. And it was a bill that had a deadline. So if we did that bill jointly, because it dealt with the Judicial Inspectorate of Prisons, and they were in agreement with the content of the bill, and it only affected them. So it was also a bit technical in nature. So there may be bills, but it will probably be less than a percentage of bills that would qualify for this. But we do propose a very careful decision-making process before we get there. Then the rules also provide for if we cannot find agreement between the two houses, because we have this joint process. We thought everything is going to go fine on this bill, but now it doesn't. What do we do? Well, then we revert back to the normal process. It goes through one house and then to the other houses committee. So those are the safeguards that we've put in, because we are required to have it. There may be instances where this would be a good idea, but we do not want this to be a situation where we are found constitutionally wanting in how we processed a bill. Absolutely agree with that. The next question related to the 3 days on the joint tagging mechanism. Mr. Baba, I think that's a good question. In practice, it is not 3 days. Our office advises the joint tagging mechanism. We ask for 7 working days before we advise the joint tagging mechanism, simply because this is not an easy decision anymore. It used to be not too difficult a decision to advise the joint tagging mechanism on, but the courts have made it very, very difficult. We now have to consider each clause very, very carefully, because just one word can render that whole bill that was proposed as 75 to be a 76. And it has happened more than once where we have recommended a 75 to be a 76. And in fact, the other way around, where the proposal is 76 and we've advised 75 for the joint tagging mechanism to consider. So the next proposal is in respect of mediation. So just one correction, the National Gambling Bill has been, I think, been hanging for quite some time, and I don't think that it's a parliamentary problem that it hasn't been referred. I think that there's a political problem. The bill is there's simply so much wrong with the bill in practice and what is wanted from the bill to achieve. And I think that is more the concern and what has happened. Parliament has done more than one mediation before. I think in the time that I've been at Parliament, I know of about 2 or 3 bills that have been referred for mediation. In each of those instances, the mediation committee was established within a few days of the bill being referred. The mediation committee had their meetings and they reported on the bill, exactly as provided for in Section 76. So it is something that has happened before. And then what has happened in Parliament is that the committee is in fact established at the time that the need arises. So I've explained that I had to go and have a look at the Constitution. And I know that the way Section 78 reads is very confusing because it speaks about the mediation committee. But nowhere does it say there is hereby established a mediation committee. It just talks about the mediation committee. Yet when we do interpretation of laws, we need to look at the whole Act and to see how the wording is used in the whole Act. And the Constitution is very clear when it establishes something, whether it's a procedure or a committee or a commission, it is very clear that something is established. So we do not have an actual establishment of a mediation committee. It's simply referred to as the mediation committee, which makes it very difficult. And of course, that is a decision for Parliament to make. And if the decision is that we need a mediation committee at the outset, then we can make that choice. I think just in practice, and what we have seen in practice is that it is more practical, more efficient to have a committee that has already considered the bill. So you have the portfolio committee, they've seen the bill, they've worked through the bill. You have the select committee, they've seen the bill, they've worked through the bill. And the two of them then becomes the mediation committee, which is what has happened in the past. And because they know the content of the bill, they know the issues, it is much easier for them to, within 30 days, reach a decision. So that was just on mediation. Apologies, I just want to quickly make sure. The issue of the 76 bill and the mandates in the select committee, yes, I fully agree with that. But Section 78 provides for specific ways of voting in the mediation committee, and that is then repeated in our rules, and that is why it looks a bit different. So it is Section 78 that we are doing there. I think for my notes, that would be the questions to me. I think the other questions are on the standing committee on intelligence and on ethics, and I'll hand to my colleagues for those.
Did you want to just speak on the 159, the more stricter process?
Apologies, Chairperson. I forgot your question. I do apologize. So it seems that from what I can get from members, I think there was also from unless I heard incorrectly, Dr. Koen have also mentioned something on 159, and Dr. Lottridge said that she supports a more strict approach. So the proposal was, one, to do away with it, but it seems that is not the one that we want. The more strict approach would to where we currently provide for a cabinet decision and then you submit the Joint Rule 159 notice. We propose that we wait until certification. Because what happens is that the State Law Advisor's Office must certify the bill. Very often, they refer that bill back to the department and say, we've got these concerns on constitutionality, on drafting, etc., etc., etc. And often the bill lies with the State Law Advisor's Office for a couple of months, sometimes even a year or more. And of course, that process, that certification process, causes significant changes in the bill. Because if there's a concern with the concept, that whole concept has to change. So what we propose is that if we want a version of the bill that will look like the bill is going to be introduced, let us then wait for certification. It does reduce the time that there is to plan. But for that, to counter that, we propose that it is also when the Joint Rule 159 is submitted, there's also an indication of how soon the bill will be introduced. So if it is going to be very soon, we will see, we are planning to introduce in the next couple of days, or we are planning to introduce in the next 2 to 3 weeks. We are just going through the editing process because editing takes about 2 to 3 weeks to get the bill properly printed after certification. So there should be enough time after certification. The other proposal is just to bring parity because private members' bills at this point in time does not have any requirement for this submission. We currently use we currently use Assembly Rule 276, which speaks to publication to make that announcement so that there is some notification to committees. So just to include them as well. And then we have a proposal that we put a little bit more of a, or rather not put a little bit more, but give a more of a role to Leader of Government Business. Because remember, these executive bills, most of the bills are executive bills, and that is where we need more cooperation, more information. So to say that there's maybe quarterly reports to the Programming Committee, and also that the Leader of Government Business facilitates that ministers per committee give regular feedback on bills that are being planned. So in other words, that committees are regularly updated on bills they can expect in the next quarter. So not just a joint rule 159, but this bill is now with cabinet. We are quite urgent for this bill, or this bill has gone to cabinet. It is just a review. It's not really that urgent. It might be coming in the next 6 to 9 months. And then lastly, what we propose is, because one of the concerns was if there is no submission, then they cannot introduce the bill. And sometimes this is a challenge where a bill is very, very urgent. And you're just not getting the minister to sign, ministers overseas, etc., etc., etc. That we then just add a rule to say that this does not prohibit you from introducing, but of course it may affect the scheduling of the bill, because that is the purpose of 159, scheduling, programming. So Chair, those are the more strict things that we propose. In other words, just to streamline, to give a little bit more of an indication, push it out a bit to certification. When are you going to introduce? Bring parity with private members, and then also allow a bit for more information to be shared between the executive and committees. Thank you, Chair.
You might want to add, was the referral by the president back to the assembly. It's not 159. Mr. Koronov thought that's 159. Just comment on that.
Yes, Dr. Koronov actually said that he needs to come back on that, to revert. And that it looks to be an improvement at first glance. So just maybe to confirm, what we have done is to look at the challenges. Section 79 is quite stark in what it says. It is very limited, but it does say that the rules must provide for the processes. So we are simply indicating that let us give more information in our processes, and also let's comply with 79 in respect of the role of the two houses. So it definitely expands on the role of two houses, and just also indicates exactly what can be amended, expanding a bit on that, just simply for things that are practically making sense, that you may need to make further amendments affecting the quality of legislation. Of course, not opening up other substantive matters, but things that are maybe just technical in nature or consequential from what the president has said. And then also just to clarify the reports, to make sure that the reports are not confusing. They speak of future tense and past tense, and then we don't know if it's one or two reports. It's one report, and with that report, you submit any amended bill, if there's an amended bill, and you indicate what you have done, so that there is clear transparency in what has been done. And then also, of course, the process in the other house, and the two speak to each other now. So we've made sure that the two processes are aligned, but also giving more information. Chair, so I think that is then it. I hope so. I hope I've not.
Thank you. Advocate Gordon, ethics. Advocate Gordon.
Thank you, Chair. Yes, thank you, Chair. Sorry, I was trying to unmute myself. In response to the question in relation to ethics was the question of our quorum. Just a point of correction, Honourable Koronov indicated that there were 9 provinces now, and through the new amendment, that's technically incorrect. The current rule, before as it is, makes provision for the 9 members of the NCOP and 14 members of the NA. So our current size is 23. The recommendation is to revise the size of the committee in line with proportional representation of how it's determined in the 7th Parliament. For instance, had it been that rule made provision for proportional representation in respect of our NA component, it means that in the 6th Parliament, we would have essentially had 11 members of the NA and not 14, but would have revised the size of the committee down to 20 instead of 23. Be that as it may, our current quorum is 12. What we find in a committee meeting when there are particularly clashes between business of the NA and
quorum is what? Your current 12, okay.
12. So what we find when let's say the business of both houses become extremely busy in terms of the program, and members have to attend multiple meetings or house business or whatever, we find that generally we have a steady stream of about 8 to 9 members who do arrive for our committee. But then we fall short of, let's say, 2 or 3 or 4 to make that quorum. So I never really thought of the suggestion of perhaps revising the quorum to solve the problem that we occasionally face in ethics where we fall short of our 12. So one, I've just been listening to the suggestion coming out today about revising some committee presentation down to a third, and that's not the quorum issue, but perhaps that's something we could look at, taking the quorum of the ethics committee forward. For instance, if we have the current 23 members, we revise it down to, let's say, a third of our members, it means that our quorum is 8. And that's essentially the number that we get as a steady stream. It's very seldom that we have a committee meeting and 2 people arrive. We generally have about 8, 9, or 10, and then we fall short of the 12 yardstick. So I think I would be in favor to revise the quorum, but of course, to just blanketly make that suggestion could have unintended consequences. We must remember that we are in an environment that is highly subjected to litigation, and we could find the scenario that people say, as the committee, we're not applying ourselves. If we are, let's say, a 20-member committee, let's say we are revised down to 20 in the new parliament, and only 6 members or 8 members, are we really doing justice to really applying ourselves to the committee? But I do take the suggestion by Honourable Koornhof that it is a possible solution to aid the ethics committee in the 7th parliament. And perhaps we should just, me particularly, go back to the drawing board and look at the Joint Rule 169 and see if we can solve that problem before the rules are adopted before the Joint Rules Committee. Thank you, Co-Chair. Okay, sorry, I keep on saying Co-Chair. Occupational hazard from ethics. Chairperson. Thank you.
I am acting Co-Chair.
Oh, right, it's a joint rule. I'm having a Friday afternoon. Apologies.
Mr. Mjengmani?
Thank you very much, Chairperson. Chair, may I please request your indulgence and ask the Honourable Babu to repeat his question on the JSCI, please? I just want to give a full answer there. I didn't hear properly. I didn't probably capture Honourable Babu.
Yeah, and as you speak, there's an echo where you are. Can you hear me?
I can hear you loud and clear, Chair. I'm sitting in a committee room here in Parliament. My apologies.
Okay. Honourable Babu, do you mind repeating that question on your presentation on this intelligence dilemma?
No, it's talking about JTM, Joint Tagging Mechanism, and it was answered that it's not 3 days. Advocate Van der Merwe said they normally do it practically within a week, but I think it may be necessary to talk about the 7 days, because there's always been a problem with the issue of consultation. It was the JTM.
Yeah, but he's answering on the intelligence clarities.
No, I wanted to understand the rationale.
Yes.
On the basis that there's a bill now before the committee. Can't we strengthen the rules based on the outcome of that process or not? And then I talked about the issue of the intelligence structures being, that committee being very, very different to other committees. And this special report, because I don't think there's anybody who wants to, I don't think people want to weaken the constitutional powers of the Inspector General. Unless we're talking about the Inspector General has to continue reporting to the committee. But I don't know why the special mechanism. That's why I wanted to understand the rationale and why a special mechanism, and whether people want to weaken, because I didn't pick up even from the Intelligence Committee that they want to weaken the constitutional powers of the Inspector General. And I was a bit surprised at the special reporting mechanism. But okay. He said, I thought he was saying JTM. I didn't hear him.
No, I've asked him to respond on intelligence issues. Mr. Mjengmani?
No, thank you, Chairperson, and thank you for that question clarification, Honourable Babu. Chair, maybe I must just go back a little bit to explain the rationale for these proposed amendments to the rules.
You might have other gadgets there that you might have to switch off, because now the echo we're competing with that echo to hear you.
It's just me and myself here, and no one else. And there's only this guy that I'm talking from. Can you hear me better now?
Okay, go ahead.
So, Chair, I was just saying that maybe I need to go back a bit and explain the background to the proposals of the JSCI to amend the rules. specifically the issue that Honorable Babu has mentioned, the issue of the special report. Chair, the JSCI reports, sorry, the Inspector General of Intelligence report to the JSCI in terms of the Intelligence Services Oversight Act. 767, Section 7, subsection 6 of this act that I've just mentioned, which is the Intelligence Services Oversight Act, provides that the Inspector General reports directly to the committee, being the JSCI, for the overall function of his or her office, and shall report on his or her activities and the performance of his or her functioning to the committee at least once a year. Now, practically, Chair, this once a year means an oversight report that gets submitted by the JSCI, by the IGI to the JSCI, once a year in the form of an oversight report called a certificate. Now, the practical realities, Chair, of the committee is that there are instances where it requires information in order to enable it to exercise efficient oversight over the intelligence services. And that information often resides with the IGI, which is the Inspector General of Intelligence. And therefore, there are instances where the committee wants to commission the Inspector General to look at a specific issue, providing an oversight report to assist it to do oversight or to exercise oversight over the executive. So the essence of this special report that is envisaged is not specifically provided for in the Act, and the committee has sought to use the rules mechanism to enable it from time to time, as it is allowed to do, ask the IGI to report on a specific issue to assist the committee to exercise oversight. So, in essence, the issue of asking for this special report is not intended to weaken the IGI. Rather, it is intended to strengthen the oversight function of the IGI, of the intelligence, the Joint Standing Committee on Intelligence over the intelligence services. So that is the intention, Honorable Chair, in response to Honorable Bob. So, in the joint rules, in order to clarify this issue of the special report, we first defined it that it is a report that will be sought by the committee on occasion from the IGI on a specific oversight issue. Just to have a basis in law, because there's also the law of, there is also the issue, the principle in law that says that you cannot exercise the power that is not granted to you by law. So the law for oversight, which the committee is exercised over the executive, comes through the rules themselves, which we are talking about now, but also through legislation in instances where there is specialized legislation, like in the instance of the Joint Standing Committee on Intelligence. The bill that is currently before the committee, Chair, does not cover this issue. And as the committee would be aware, in instances where we had to inquire into other aspects of the legislation which are not in the bill that is currently before the committee, the committee would have to approach the assembly for permission to do so. And therefore, the committee thought that it would be cumbersome to follow that process when all it wants is already in the law, but it will be further explained in the rules that operationalize its work. So that's just the issue around the special report, Chair. I must also just mention that there are instances where the IGI has found himself in a predicament where the committee asked for this special report. Because in the Act, it's not explicit that the committee can designate him or direct him to bring about this report. Hence, the committee thought the joint rules in Schedule B, which empower its work, could provide for this special report. So this is the mandate of the JSCI through the chairperson of that committee. And therefore, this is in response now to Honorable Dr. Gordon who was talking about the issue of consultation. So my comment is not a replacement for the consultation that must take place as the doctor was talking about. But I'm simply saying that this issue about the special report and the proposed amendments that we are presenting here are at the instance of the Joint Standing Committee on Intelligence. And then, Chair, the issue of the deputy chair, it is only in instances where the chairperson is incapacitated or is unable to perform his functions or duties that the acting chairperson would be engaged, Chair. the rules themselves in joint schedule B provide for the acting chairperson. It is only that issue of the acting chairperson briefing or handing over back to the chairperson on his return that we were trying to provide for, to try and make it less onerous. That's the proposition in respect of that issue, which I just read earlier. And lastly, Chair, on the issue of processing legislation, I would like, Chair, viewing that, would like to go to the Constitution in section 45, subsection 2B, which talks about, maybe I must just read it, Chair, before I expand on it. It reads as follows, Chair. The National Assembly and the Council must establish a joint rules committee to make rules and orders concerning the joint business of the Assembly and the Council, including rules and orders too. So we go to B, Chair of the Constitution, it reads as follows. To establish joint committees composed of representatives from both the Assembly and the Council to consider and report on bills envisaged in section 74 and 75 that are referred to such a committee. Now, Chair, this, as it is quite explicit in the Constitution, gives the joint committees the power to process legislation. To process legislation that is referred to them. I want now to explain the context of the JSI, Chair, and why it is that they are requesting that the committee look at the possibility of amending the rules or providing for a procedure for joint committees to process legislation, as is given in this section that I just read. The Act which establishes the JSI in section 3 grants the JSI the power to can you hear me, Chair?
Chair,
Just pause, Mr. Mjengwane.
Chair,
Yes,
I'll be lying if I can say to you I hear the presenter. Unento ngathi ziyacula kule nto ubuyisho into yoba kune echo. It's like he's singing. We can hardly hear him. And what he's presenting is very important.
Okay.
He needs to be a little bit audible, please.
Yes. Thank you, Chief Whip. Maybe we'll give you a minute or so to reposition yourself where you are, because I thought I was the only one struggling, but it was getting worse instead of getting better. Mr. Mjengwane. While she's doing that, members, are there any follow-ups from the responses from the presenters on these issues? If none, we proceed. Honorable Kurenov.
Can you hear me better now, Chair? Sorry.
I will come back to you, Mr. Mjengwane.
Thank you, sir.
Thank you, Chairperson. No, just 4 quick points. Indeed, the bills refer back to the President is in Part 8 of the Joint Rules, Joint Rule 202-208. That's fine. Thank you. Just secondly, on the joint committees, and it was addressed while we were couldn't hear properly. I just want to confirm on the joint committees where the legislation is processed together by 2 specific committees, one in the National Assembly and one in the National Council of Provinces. If the joint rules will allow for that and we park it under the ad hoc committee section, I don't have a problem. I just want to have clarity that it will be possible to process legislation together of 2 identified committees within the same environment and portfolios to do it together. Where we park it in the joint rules and amendment, I don't have a problem with that. But the principle of processing legislation together, of 2 committees working together and approving the same piece of legislation. I just want to, and the gentleman was about to explain that. Then on Advocate Gordon, thank you for the clarity. I think it's a fine balance to have a workable working ethics committee and to address the challenge of not having a quorum from time to time. I would be very hesitant to amend the quorum. The committee needs to be very careful and get legal advice on that. But at the moment, the issue, we must have a working and a functional ethics committee. And it pains me to see that the committees can't meet because of lack of quorum. So we need to, I agree with you, be innovative and see how we can assist committees, such committee in the 7th Parliament to work effectively. And my last point on Joint Rule 159, I just want to confirm the original idea of 159 is for the member of the cabinet or a cabinet member or the deputy minister, after the bill has been approved by cabinet, to submit it to the speaker and to the chairperson of the NCOP. The aim of that was to give early warning to both houses. This bill has been approved, it's on its way. And it was one of the aims was to have early line of sight of the bill coming and to provide more time for committees to prepare. I just want to have confirmation that we will not lose that if we change it to wait for the certification of the bill. That was my understanding of the original benefit of a Joint Rule 159. Thank you, Chairperson.
Thank you, Honorable Korenov. Honorable Chief Whip.
Thank you, Honorable Chair. Honorable Chair, just to follow up on what Dr. Korenov has just said, I think the proposal cannot be establishing lot of joint committees. But where we know that this bill is also, the briefing will happen in the NSOP, in the NA, it must also happen in the NSOP. The bill that will move from NA to NSOP, where possible, we should have joint meetings in dealing with such bills. I will tell you why. Currently, there is delay in terms of bills. And from the NA side to the NCOP, from NCOP to provinces for public hearings or whatever. But if at a go where we think that we can have joint meetings, let our rules be flexible without establishing joint committees on each and every. So currently our rules and joint rules are not flexible for joint briefing, for instance, and we know NCOP might want to go for their mandates, be it negotiating or final mandate, but on the start is what we were proposing. Thank you.
Thank you, Honorable Chief Whip. Any other follow-up before I invite Ms. van der Merwe and Advocate Gordon? And then we'll go back to Mjengani. Hopefully he is well positioned. None. Ms. van der Merwe, you're back with us.
Thank you, Chairperson. Yes, definitely there is provision for committees from both houses to have a joint process. In other words, they'll sit as a joint committee. There will be a joint committee report once they report on the bill. That report will first go to the Assembly for second reading of the bill, then to the NCOP without having to go to a select committee, directly to the NCOP for agreement with the report and the bill. So definitely provided. We also have provision for conferral between committees. So for instance, the Electoral Matters Amendment Bill, we have made use of that conferral power, where committees of the two houses can sit together, get the briefing, do the public participation, and so on. On the Joint Rule 159, I hear the concern on certification. The challenge was to address a different concern, that the bill changes. I think the idea that I'm getting is that members definitely want 159. Whether we do after cabinet approval or certification, I think it just addresses the issue of whether the bill is similar enough to take instructions on. But if members want it back to the cabinet decision, we can do that. It is not something that is it was simply a proposal to try and assist on certain things, but we can definitely go back to cabinet.
Before you proceed, the issue here, which is critical, is to allow Parliament for early planning. Because that's been the problem dealing with. We want early planning. So any of those two options, it's important that Parliament gets heads up on the first of those that kicks in, so that Parliament has got its program quarterly and yearly. So that assists those committees to schedule and budget for these kind of processes. So there's a lot that goes into that. Hence, I spoke about hospital passes. I didn't elaborate what I mean. Those who play rugby would know what that means. It's when somebody keeps the ball with him, you don't pass it until you are in trouble, and then you just throw it away, and the one who catches it is immediately found with the ball and is tackled and wakes up in hospital. So it's a selfish approach of doing things, and we want to get rid of that.
Thank you, Chair. I definitely understand. So what we'll do is we'll go for the more strict approach, so the second option, and we will simply change certification back to cabinet decision. So that will then remain. So after the cabinet decision, there must be this referral to Parliament. So we can definitely do that. And then I think from Ms. Machotina was also the issue of the joint committees. There's definitely provision for it under ad hoc committees. Definitely clear provision made that it can also deal with legislation. And then also, of course, the fact that we do have the conferral process available. I think those are the only things that I could see for me. Thank you.
And once we have that, Ms. van der Merwe, it also helps the certification process. You did say it takes a lot of long time, months and up to years. That on itself, nothing stops Parliament to oversighting that, because we would need to understand why the certification would take 2 years, for example, and so on. So it put a spotlight on every milestone that you have, including the certification points. Thank you for that.
Thank you.
Advocate Gordon.
Thank you, Co-Chairperson. In response to the matter, in respect to the matter raised by Honourable Koornhof, I think that, it's easy to say let's revise the quorum. But as I mentioned earlier, it's a very serious committee. It's a committee that's seized with important work. And I do think that perhaps in the 7th Parliament that the problem will solve itself. I think that when we look at the joint rule as proposed earlier, to revise the size of the committee in line with proportional representation of the NA, I think when that is aligned, it will essentially address the issue of quorum. If we had had that scenario in the current 6th Parliament, I would have had a committee of 20 members and the quorum would have been revised down. But because we were stuck with a legacy provision, it resulted in the quorum being greater than what it actually should have been. So Chair, I think that I don't think the joint rule in respect of the quorum should be touched. I think that the recommendation for the amendment of the composition of the committee is what should go through, and that in practice for the 7th Parliament should resolve itself. Thank you, Co-Chair.
Maybe before you go away, just to share with us, because I don't know how long you've been there, but your committee is different, because whereas others can easily meet virtually, my understanding that it has to meet physically. And I don't know what's the track record of that committee when you pre-COVID, when you did not have these virtual setups, when the requirement was physical and people were in Parliament, because it might even invoke, therefore, what kind of support and the resourcing you need to do, because it's not like other committees. Its requirement is correctly that people must be there in person, than Justice Committee meeting virtually, where we have no problem of a quorum. So have you looked into those things and maybe made those kind of comparison as to, has it always been like that, to create a problem of quorum, or is that a new thing altogether?
Thank you, Co-Chairperson. Just to give a bit of background, I've been with the Ethics Committee for almost 6 years now, since 2018. So I've had the opportunity to come with this committee since the business of the 5th Parliament into the 6th Parliament. I think at the end of the 5th Parliament, when I inherited the office of the registrar, I think the work was substantially backlogged. and we've made huge inroads from the 5th to the 6th Parliament. Going into the 6th Parliament, the matters that lapsed as business before the Houses lapsed at the end of the term, we took a decision as a committee in the 6th Parliament to revive certain matters, and certain matters were brought anew by the complainants at the start of the 6th Parliament. Now, then COVID came in 2020. That was our first meetings of the committee was 2019, and COVID came in March 2020. During the COVID time, we didn't meet because of the fact, as you correctly stated, we meet in person. It's a committee where we don't take chances with people's personal information. It's a committee that deals with financial and registrable interests. And also in the light of the POPI Act, we have to take all those information that's before us in a very serious, strict confidential light. So we meet in person. We also don't disseminate documents before our committee to make sure that we don't have the situation where an email is sent incorrectly, maybe to the wrong person. So we make sure that all our documents are disseminated in hard copy before members on a day of a committee, and the files are returned to us at the end of that committee meeting. So as 2021 unfolded and the COVID restrictions lifted, we were able to meet more frequently. We did make up the lost time, and currently the Ethics Committee has no backlogged files. We are up to date, we are current. I know that there tends to be this narrative that we have backlog, and I wish to categorically state I have certain members of my committee on the platform as well. There is no business before the Ethics Committee that's backlogged. Everything that we were required to do for 2023 has been processed. Our committee reports have been ATC'd. Members have been receiving their penalties. We've had to fend off litigation in the High Court. So we are very active.
That's fine. I can see you're passionate.
Yes.
Don't go deeper.
So we have made up for the lost time of the COVID years. Yeah. It is a very interesting question going forward into the 7th Parliament, but it's a challenging environment. It's one that we haven't found a solution for yet. But perhaps in the 7th Parliament, Co-Chair, we will be reaching some measure of success in how to solve that problem. Thank you.
Thank you. Thank you. Mr. Mjengane, please conclude, and then I'll go to Mr. Nonyane.
Thank you, Chairperson. Can you hear me better now, Chair?
It sounds better. I hope it will stay like that.
Okay, no, thank you, Chair. Chairperson, I was just explaining
It's not
the
better.
issue. Is it not better?
No, just give him time. Just be patient, Mr. Goronov. Kobe.
Chair. Chair, I'm sitting in a committee room. I must apologize to members for the sound. I'm sitting in a committee room which is empty. That's probably where the echo is coming from. I've tried to move now closer towards the door just to clear the issue of the sound. Chair, I was talking about the issue of the JSCI being a specialized committee that is established by legislation. Firstly, it is contemplated in the Constitution, in Section 199, Subsection 8, and established by the legislation, which is the Intelligence Services Oversight Act. Amongst the functions of the committee in the Act that I've just mentioned is its power to consider and make recommendations on all proposed legislation related to the intelligence services and any other intelligence and intelligence-related activities, and to initiate legislation in connection with the services. So that's the general power of the Joint Standing Committee on Intelligence, to create legislation that governs the intelligence services. The only issue, Chair, that has constrained the committee from exercising this power is the fact that Section 73, Subsection 2 of the Constitution does not envisage that members of a joint committee may introduce legislation in any of the houses. So this has constrained the committee. Members would remember that currently the National Assembly resolved that there would be an ad hoc committee that would look at the General Intelligence Laws Amendment Bill, a bill that could have been processed by the Joint Standing Committee on Intelligence in terms of this section that I've mentioned. But because there was no procedure to do so, it is now being processed in terms of that resolution I've mentioned of the NA by an ad hoc committee of the National Assembly. So, Chair, then the committee considered this matter and resolved that it would approach the Joint Rules Committee and request that in terms of Section 45, subsection 2B of the Constitution, that the procedure for joint committees such as the specialized one, which is the JSCI, or any other joint committee, be provided with a procedure in the joint rules to process legislation within their purview. However, Chair, as matters currently pertinent, there is no such procedure. Hence, the committee requested that there be a process through the rules review process to provide for a procedure in them. So that's the background, Chair.
Okay. All right.
Yes.
The
other issue, Chair.
Yes.
Sorry, I beg for your indulgence, Chair. The other issue is the issue of the special report which Honorable Babu asked. The special report, Chair, that the JSCI envisages is one where the civilian oversight body, which is the Inspector General of Intelligence, who also oversees the services by report to the JSCI and reports at least once a year in terms of the Act. There have been instances where the committee would like to be empowered by his reports in order to strengthen its own oversight mechanisms, but lacks the mechanism in law currently to do so because it is not explicit in the Act. And therefore, the committee looks to the joint rules, the Schedule B that governs its work, and mentioned that it would want to propose to the joint rules that the special report be provided for, where it could use that mechanism to request using the Schedule B of the joint rules from this civilian oversight body called the Inspector General of Intelligence for special reports from time to time in order to enhance its work. So those are the two issues, Chair, that we had tabled here today. Thank you very much.
Thank you. Just before I come to you, colleagues, as a way of wrapping up, Mr. Nonyani, any comments you want to make?
Thanks, Chairperson and honorable members. Chairperson, on my side, there isn't anything really any comments to make. Just to highlight to the Chair that we still have Chapter 5, which I'm not sure what was your view, whether we proceed with it today. It's not a long chapter. It deals with the stopping of funds to provinces.
We're still going to Chapter 5. I want to wrap up this part.
Oh, thanks, Chair. No, on my side, there aren't any questions that I still need to respond to.
Thank you, Mr. Nonyane. Colleagues, I want us to proceed to the next, but I wanted to check with you the discussion on chapters 3 and 4, whether from this joint subcommittee, do you feel that the matters we dealt with are ready to be proceeded to the joint rules and the two houses, or whether there are few areas that you still want to have a second bite on before that happens? Are we comfortable with that? Before we go to chapter 5, chapter 5 will be brief in the schedule. Can I have a comment on that? Mr. Honorable Korenov.
Chairperson, broadly speaking, I get the sense there is agreement on the chapters presented. So I would be very hesitant to delay it further. We're working in a very tight time frame till the end of the 6th Parliament. And every day or week we lose now is going to put more pressure on the two houses. So I would suggest that that broadly speaking, we accept what was presented with appreciation. And if there are any other feedback that we need to give to the officials and the advisors and the staff, we're free to do it. Thank you.
Thank you, Mr. Korenov. Honorable Lottridge.
Chairperson, thank you. Yes, I also think we have had the opportunity to give our our concerns, to convey that, but I think in the whole it is ready to be presented to the joint rules. Thank you.
Thank you, Honorable Lottridge. With those comments, colleagues, we will step off this item. There's work to be done based on these comments from the 4 presenters to polish and enrich the discussions that would have been here on chapters 3 and 4. So let's leave that for now. Can you go to the last item, chapter 5 and the schedule?
Thanks, Chairperson. Chair, as I indicated earlier on, chapter 5 is on the stopping of funds to provinces. And in fact, the joint rules tries to operationalize what is provided for in terms of section 216 of the Constitution. If Chair, through your permission, before might be I delve into the rule itself to just read what the provision of the Constitution provides, because of then we will be looking at the rule as to whether does it cover what the Constitution requires. Section 216 sub 3 in particular of the Constitution provides that a decision to stop the transfer of funds due to a province in terms of section 2141 may be taken only in the circumstances mentioned in subsection 2 and may not stop the transfer of funds for more than 120 days, and B, may be enforced immediately but will lapse retrospectively unless Parliament approves it following a process substantially the same as that established in terms of section 7176 sub 1 and prescribed by the joint rules and orders of Parliament. The process must be completed within 30 days of the decision by the National Treasury, and sub 4 provides that Parliament may renew a decision to stop the transfer of funds for no more than 120 days at a time, following the process established in terms of subsection 3. 5 says, before Parliament may approve or renew a decision to stop the transfer of funds to a province, the Auditor General must report to Parliament and the province must be given an opportunity to answer the allegation against it and to state its case before a committee. The initial rules that were contained in the rule book, the joint rules, were kind of, in a way, not giving effect to what in a sense that it make reference to the tabling of the motion from the Minister of Finance to the National Assembly, whereas the Constitution was ambiguously clear that it is Parliament that needs to do that. So what we then had to do, members will see that we had then to amend that, to propose amendments, in order that at least it gives effect to Parliament, but also Rule 223 sub 1B to then specifically indicate that the motion should outline the reasons why funds for the province have been stopped, as the Constitution clearly outlines that. You may move, but two to be deleted and sub 3 to be deleted. 224 that deals with the establishment. 224, yeah, to specifically make reference to the fact that an ad hoc joint committee known as an ad hoc committee on the intervention of provincial funding must be established by a resolution adopted by both houses. And as members will have noted that the Constitution has certain time frame, when there is recess, to then also made a provision that in those instances, then the Speaker and the Chairperson acting jointly after consultation of the Chief Whip of the Majority Party in the NA and the Chief Whip of the Council should be able then to establish the committee. You may move to Rule 225. The rest we propose that they will be deleted. Okay, maybe before that, I might have missed just one, just there. Pause, yeah. The sub 2 to then specifically make reference that the speaker and the chairperson of the council act must refer the motion for a report and recommend to a joint ad hoc committee on intervention on provincial funding. The composition 225, the composition as well, just to streamline it, we are proposing that the ad hoc committee should consist of assembly members appointed in such a way that the number of assembly members is equal to that of the National Council of Provinces. And the parties in the assembly are represented substantially in the same proportion that are represented in the NA. And B, the council composition should be in such a way that each province is represented by 2 members, and sub rule B, Roman figure 2, each party in the council that does not have the majority seat in at least one of the provinces is represented by a member. This is in line with the rules of the NCOP, where in those parties that may not have a provincial whip represented, then they will, in proportional to the composition of the NCOP, also be enabled to participate in the committees. The chairpersonship, that is Rule 226. Scroll up, yeah, just there. The chairpersonship is similar to what I think we spoke about earlier on when we were talking of chairpersonship of a joint ad hoc committee. A member of the assembly component, they will elect the chairperson of the joint committee component of the NA, and the NCOP component as well will elect the co-chairperson from the NCOP component. 225, that is the function of the joint ad hoc committee. We try to streamline that in such a manner that there's a flow in a way in which the work of the committee should be undertaken. First, it will be the minister, of course, having to brief the committee on the rationale for the stopping of funds in terms of the constitution, and thereafter the auditor general then to report on his or her finding, as his finding or her finding will have influenced the decision that the finance minister will have taken, and for the committee to investigate the matter, and having done so, then to afford the province as well an opportunity to state its case as provided for in the constitution, and thereafter then for the committee then to deliberate and decide whether they approve or reject the motion on the stopping of funds. If done, then to provide for the report of the committee within 5 working days to be out in order to work towards the 30-day period that the Constitution provides the committee to finalize its work. Rule 227 is mainly around, 228, the decision of the committee, and of course the decision of the committee will be taken when there's an agreement between the assembly component and the NCOP component. And of course, based on the fact that the NCOP vote differently, then the NCOP component will follow its processes to vote, and the NA, and the outcome of the two then will determine whether there is sufficient majority then to get the resolution adopted. Then in respect of Rule 229, which I think once that process is completed, the matter then will be referred to the houses for consideration of the report. Really, I'm not going to waste members' time here because of it is the same process that the NA follows when considering reports before them. except just some minor proposals there, and the deletion of the sub-rule 3B. Can you go to the next rule? The same there as well is the process that the NCOP follows. We didn't tamper that much with the rule. And however, take into account that the Constitution also specifically makes reference that the process should, in a way, mirror that process that is outlined in Section 76(1). This is where, for an example, the two houses may not agree, which is possible, taking into account that the NCOP's interests are to provinces. They may have look at this differently. We then make provision for the mediation committee, which will then mediate the dispute between the two houses. You can go to Rule 232. That as well, there wasn't much really, just to reiterate or emphasize the timeline that is being provided for in the Constitution, that at least the committee as well is mindful of that. And Rule 230 is instances where, for an example, because of, in this case, the Constitution only make provision for the stopping of the funds for a period of 120 days. However, that can still be renewed. So we then reiterated that once that period, Parliament could still renew that process. And in so doing, the same process will be followed, which will then be looking as to where those matters are addressed and so forth, before then again a report and a renewal. Chairperson, I think that should then bring me to the end of this provision on Chapter 5, dealing with the stopping of funds to provinces. Thank you very much, and I think my colleague might want to come in respect of the schedule. Thanks, Chair.
Let's allow the schedule to be presented. Thank you. Who is the colleague, Mr. Nonyane?
Part of the schedule, I think, talk to intelligence. I'm not sure, maybe he has already covered those aspects already. Yeah.
And then, who are we waiting for?
Mr. Mkwechana, sir.
Is he still around? He was alone in that committee room.
They were covered, Chair. He covered this aspect, Chair.
Okay,
when he presented. Thank you.
No problem. So there's no need to present it. Thank you. Thank you, colleagues. You can remove that. There's your Chapter 5, honorable members. Your comments, clarities, or contributions? Are you still here, or you've just logged in?
Hayi sikhona simamele Chair, sikhona Chair.
Honorable Kurenov. I was about to start now. Honorable Kurenov.
Chairperson, no, I think it's clear. I think we're happy with both presentations. The previous one, Schedule B, we discussed with the Joint Standing Committee Intelligence. We covered that. And Chapter 5 is straightforward. So I think I don't have any comments. Thank you.
Thank you. You fell short of proposing that we wrap up, but any other member? None. Thank you.
No.
Thank you. Ms.
We are
Naba?
covered. We are covered, Chair.
You're covered. Okay. Thank you. Anything you want to raise, Mr. Onyane and your team?
Not that much, just to thank Chairperson yourself and the honorable members for the direction that you have given us. And I think I'll be speaking on behalf of my colleagues as well, that from here, at least we got the clear marching orders as to what still needs to be done on our part in order then to prepare the report for the subcommittee, which probably will also be serving before the Joint Rules Committee. So on that note, Chair, I think once more, thank you very much from our side, Chair.
You're not done. Have you as a team considered any possible date for the rules, joint rules? Or you will see as you go?
We will prefer that maybe, Chair, we engage with the co-chairpersons and also take into account of the work that we'll be doing, so that at least we can then get a direction from there.
Okay. All right. Thank you, Mr. Nonyane, and thank you to all of you as our support staff, all of the 4 presenters. Mr. Manyange, I have your hand up as I want to conclude.
Thank you, Chair, and sorry for interruption. I just want to answer the question related to the meeting of the Joint Rules Committee. The information that I have is that we are looking at the 22nd of this March as the date of the Joint Rules Committee. Thank you.
Okay, that's very important for our planning. We deal with so many things, so that helps. Tentative date, if there are going to be changes, will be informed. So the co-chairperson will work on that. Thank you very much. As I was saying, thank you to all of you as our support staff, all the 4 presenters on their work. Well done. Thank you to all honorable members who logged in from 12 o'clock. It's now 20 to 4. We're able to go through this for your patience and duty of work. Some would have started as early as 8:30. So we have been dealing with matters of rules this whole morning. Thank you very much. The meeting is now adjourned.
Thank you, Chairperson, for your leadership.
Thanks, Chairperson.
Mkusele, don't close the platform.
Okay.
If we can remain just for 2 seconds to once members log off, just to deal with the logistics moving forward.
Thanks, Chair.